Everyone, I declare open this public hearing of the Standing Committee on Employment, Workplace Relations, Skills and Training for its inquiry into the operation and adequacy of the National Employment Standard. My name is Libby Coco. I am a member of this committee. The chair is been challenged this morning by the transport system, and I'd like to just acknowledge that she is taking our public transport system. Well done to her, and she will be here, I would say, any minute, but due to time we will commence. I begin by acknowledging the traditional custodians of Naarm, where we meet today, and for those viewing proceedings online, the traditional owners of the lands that they are on as well. I pay my respects to ancestors past, present and emerging, and extend that respect to all Aboriginal and Torres Strait Islander peoples and their cultural and spiritual connections to Australian lands and waters. In accordance with the committee's resolution, this hearing will be broadcast on the Parliament's website, and the proof and official transcripts of proceedings will also be published on the Parliamentary website. I remind all present that, in my role as acting chair for the moment, I will ensure that proceedings are conducted in an orderly, respectful and courteous way. Those present here today are advised that filming and recording are permitted during the hearing. I remind members of the media who may be present or listening on the web of the need to fairly and accurately report the proceedings of the committee. I now welcome representatives from the Chifley Research Centre to give evidence. For the Hansard record, could you please state your full name and the capacity in which you appear before the committee?
Thank you, Acting Chair. My name is Emma Dawson. I'm the Executive Director of the Chifley Research Centre.
Thank you.
My name is Sarah McKenzie. I'm a Research Associate at the Chifley Research Centre.
Well, thank you very much for coming today and sharing your knowledge and wisdom with us. Would you like to give an opening statement?
Yeah, I'll give a brief one.
Thank you.
So,
Hello, Chair. So if you would like to...
Wait a moment, if that's okay.
Yeah, let's wait. We will wait for the chair to get settled in.
Won't be long. Done an excellent job getting us started, and I look forward to hearing our opening statement. So, our submission is whether Australia's workplace safety net is still 55% changing in labour market. There's significant parts of it that needs to be work. The National Employment Centre, as you know, the foundation of Australia's workplace safety net, they're intended to provide minimal protections for workers, regardless of their bargaining powers or circumstances, but they matter most for those who have power in the labour market. Workers that are award-reliant, insecure work, and have little practical ability to negotiate better conditions for themselves. That's why our submission focuses on changes to how the National Employment Standards impacts and works for casual employees. Casual employees make up a significant part of the workforce, and many are performing regular and ongoing work. We know that casual employees get a load-in, and that will be the pushback to our suggestion that they should get paid annual leave and paid personal leave prorated like any other worker. But we say that that load-in shouldn't just be thought of as compensation for foregone leave, that it should reflect the fact that the risks associated with insecure work sit disproportionately with workers, with casual workers. Annual leave and personal leave do a lot more for not just the individual and not just the workforce, but the whole community. actual money that they take home, they are earning less than their permanent counterparts. Not just workforce-wide, but when we look at it based on skills, occupations, industry, gender and age groups, casual workers take home less money, even with the 25%, than permanent counterparts. And that, to us, that tells us that there are structural differences in bargaining power, and it's not simply workforce compensation. And we would argue that the national employment standards, this safety net, is most important for these workers, yet they are cut out of so much of it. So that's why we focus so much on that. We also note in our submission, we're really pleased this is happening. There have been changes to the national employment standards, but it has been 16 years. And we would like to see a more regular review of national employment standards. Those changes made in 2022 that explicitly recognise the importance of promoting job security and gender equity in the Act, they require us to say, well, does the national employment standards hold true to that? And we're going to see more changes in the workforce, more changes in other parts of the Act, and we want to make sure that there's a mechanism that governments can regularly be advised by an independent body telling them, you should have a look at this, you should have a look at this, and you should change that. That's excellent. My opening statement.
Excellent. Well, thank you very much. And I may take my chair's prerogative to start with some of the questions. And perhaps we'll start where you finished, which is around the regular review. This is something I think we've discussed a little bit in this inquiry already. And it's interesting to hear, kind of add to some of the voices around wanting more regular reviews. In terms of what that would look like, just wanting to kind of draw that out, how would a good regular review system operate? Who would be responsible for administering it? What would be the time periods you think would be most appropriate? Would there be anything that would trigger a review?
Yeah. Look, I haven't thought about it in such detail.
Okay.
I do think that it would likely be something that would happen within the Fair Work Commission, similar to, the other reviews, other sort of minimum wage review, but I'm not saying that it would need to happen every year. I suppose what we've seen is a pattern of there are changes to the national employment standards really only in the last couple of years or so. We can do some guesswork about the changing nature of work, but really things are moving very fast in technology, the rise of artificial intelligence. So I would say that you'd be wanting to do it at least within each term of government. And it would be something that would advise the government. Whether they take on those recommendations or not, obviously, is for the government of the day and the parliament, but something that is open to the public, so that we can see what the advice of an independent group like the Fair Work Commission is making around national employment standards.
Okay. I mean, the minimum wage where people make submissions? Is that,
yeah. I mean, that's what I'm imagining it to be, but it could be any sort of thing. Just, I'm not here to say exactly what the mechanism is, but I am just here to say that we're lacking one, and it's not until inquiries like this are initiated, which I congratulate you for doing, that we can start to dig into it, and it just shouldn't be because there is a government that wants to look into it. This is something that impacts all Australian workers.
I think that's the high-level principle, Chair, is that it shouldn't be left to just the whims of the government of the day or to a reactive process driven by the Parliament to regularly review the standards as they apply to a rapidly changing workforce, and therefore inserting something into the Act to require some sort of regulatory or statutory review of the operation of the NES every 3 years or so. We think, given the nature of the economy and the changing workforce, is something that the Parliament should consider recommending to the government.
Excellent. Well, thank you very much. It's very helpful feedback. Really interested to hear your reflections on the casual workforce and insecure work. Obviously, there have been a number of changes in the Act around insecure work, including the requirement in the previous, with the previous government around casual conversion, clauses and requirements for those, for employers to put the request to workers. Do you have any thoughts around that? How's that working? Or where there could be improvements?
Look, the submission didn't go into detailed work on those, what is it, section 15 or something of casuals. What we are pointing to, and obviously those reviews have happened before, but what we're pointing to is that there is a large amount of casuals. The conversion will allow some casuals to move over, but it won't for every casual employee. I don't think that we're going to go from 1 in 5 employees to, 1 in 20 in a number of years. We've got a huge amount of people that are currently cut out of significant parts of the National Employment Standards that carry a lot of risk as workers. And I suppose that's what we are getting at here. Whether the conversion works or not doesn't really impact the fact that we think that if you are casually employed, you should be able to have paid personal leave and paid annual leave. And I just want to go into that point as well because, I've thought about this and the possible pushbacks, as I already raised, this idea of, well, they've already got the 25% loading. Of course, we say that they don't earn as much, but no other worker is required to insure themselves against getting sick. So when I'm sick and I have paid sick leave, I'm not also losing my wage for that week. And casual employees, we don't expect them to take their 25% and put it in a box under their bed and go, just for when you're sick. We also don't expect any other worker to work potentially every single week of the year without a break. And that is something that casual employees can be expected to do. Now you say, well, casuals don't have to accept the shifts, but we know that they do. We know that, if you're rejecting shifts as a casual employee, you're putting yourself at risk of not having any more shifts in your workplace, ever.
I can add to that slightly. I think the casual conversion measures that were, and amongst many other well overdue changes to industrial relations laws that were passed in 2022 and 2023 are an important right, an important ballast for some of those very insecure workers. But as my colleague has said, many casual workers will not be eligible for that or will not pursue a conversion to permanence for a number of reasons. The fact is that the system as it was designed, as again Sarah alluded to, was on the assumption that a significant additional hourly loading to your rate of pay would compensate for the loss of that leave, on the assumption that that workers can somehow set aside some money for a rainy day. The prevalence now of casual work in our economy, the proportion of it of which is award wage and minimum wage paid, combined with the pressures on families and cost of living, mean that is a completely unrealistic expectation. Moreover, there is a plethora of research, not just from ourselves but from University of Melbourne and others, to show that very few casual award wage workers do receive a 25% loading. They're much more likely to receive, if anything, up to 5%, depending on their award. And so the loss of that access to sick pay not only jeopardises their regular income and their household well-being and security, but it also, as they are workers that tend to be customer-facing, award wage workers in retail, in hospitality and in the care sector in particular, then they are putting at risk the other members of the public, and in many cases very vulnerable people, by having to go to work because they have no other option. So as work is changing, the idea of a standard job being a full-time permanent position is long in the past, and we are only seeing more, despite the government's excellent efforts to pull some of that insecurity back, more risk going on to people in the workplace than we do think, and that's a reason for the regular review, that it's time to consider giving that essential safety net to casual workers for that reason.
Thank you. Ms. Coker, do you have a question?
Yep, thank you, Chair. And good morning and thank you for being with us today. I'm just interested in going back to casual workers, you suggest that we need to extend paid parental leave and annual leave entitlements to casual employees.
Did I write
paid personal?
Personal leave, yeah.
So, in regards to that, when do you think that needs to be put in place? When someone begins work, or after a certain period of being a casual worker? What are the parameters around that?
Yeah, I mean, and again, this is a sort of principled position. There could be different mechanisms for how you do it, but I don't see any reason why it shouldn't start from when you begin work. There'll be some difficulties, I acknowledge that, with, the irregularity of some casual work, but employers already deal with that when they're calculating, tax and super and a whole lot of other things. But yeah, I don't see any reason why you would need to wait, say, 6 months or something. No other worker is required to do that for their leave entitlements.
And out of the, you also have talked about sick leave. Do you think that if there was priority given to the type of leave that a casual worker could receive, would you say that sick leave should be a priority?
Yeah, I would like to see both. I think that annual leave and sick leave serve different purposes. If you had, a certain number of days of annual leave and not paid sick leave, I think people would use their annual leave for sick leave. But if I'm thinking about not just the individual worker, but the workplace and the wider community, personal leave serves a really big purpose in that space. We know that people go to work sick because they cannot afford to not go to work. We saw that during the pandemic. It's why government stepped in and put in place arrangements to help casuals take time away from workplaces and not spread diseases that would cause significant health issues. So, yes, that answers your question.
We would prioritise sick leave. If there was to be a choice, sick leave would be the first priority.
Can I just ask
I
one
think
more?
also, sorry, just to add to that, if it did have to, come down to that sort of choice, it also most fits in with the new objects of the Act around promoting job security, and it would, I believe, show that this would be quite an easy exercise. Sure, it would have costs attached to it, but it would be quite an easy exercise for employers to work out prorated sick leave on casual employment and different casual employment patterns, which then, with this regular review process, we could look at other sorts of leave.
Okay.
I'll make sure Ms Fernando gets a chance.
Can I ask one quick question before I hand over to Ms Fernando, who is online? How would this... So at the moment we have a 25% loading for casual workers. If casual workers are receiving these other benefits, which are the same as permanent workers, should they still receive that 25% loading?
Yes. And as I sort of said at the beginning, I don't think it should be viewed, which I appreciate has historically been as sort of a buyout of leave. I think it should be reviewed almost as a danger loading, a risk loading, an insecurity loading. And we should be encouraging and using this system to encourage employers to provide more secure workplaces for the workers that they rely on to run their businesses.
All forms of casualisation of work are effectively a means of shifting the risk of business operations from the business owner onto the worker. If a permanent staff member, a business owner, has to take on the risk of managing fluctuating demand, fluctuating workplace needs. With casual staff, that risk is put onto the worker. We're not saying there's not a place for casualisation, and certainly if every casual worker were receiving 25% higher than the rate of pay for a permanent worker, that argument would be harder to make. But as I've said, the evidence is that very few of them are. Some of them, in fact, have a wage penalty compared to permanent workers, and I'm happy to provide evidence on notice of that finding.
So it's in our submission as well. We're saying the gap between permanent workers and casual workers, not just workforce-wide, but if you look at it in their skill levels, in their occupation levels and in their industry levels, casual workers are taking home less money. It's across the whole workforce. It's $12 now. It keeps on going up. And that's because of those structural differences between permanent workers and casual workers. The fact that less of them are in unions, they're more likely to be women. They're more, that side of it. So yeah.
Thank you.
Sorry, I know you've got.
No, this is great. No, that cohort level of detail is very helpful to understand as well. So thank you. We'll just throw to Ms. Fernando. I believe you're on the line.
Thank you, Chair. Thank you so much for being here this morning. As we know, the NES hasn't been looked at for over 16 years. What do you believe the most important amendment that needs to be made to the NES so it's fit for purpose for today's working environment?
Look, our submission focuses on a couple of things, and I'm not going to say that they are the most important. I've read through the other submissions that this committee has got, and there is a lot in there, particularly around working hours, that I think should be taken really seriously by this committee. In this inquiry, we do say that this what we're suggesting around casual employees getting paid personal leave and paid annual leave is important because it is such a large amount of workers, a large section of the workforce, workers who are most likely to not be able to negotiate themselves, and the safety net is meant to be for that cohort. But I am sure that there are other areas. I think what ties together a lot of the parts of other submissions around significant changes is those that are focused on making sure that those workers who cannot negotiate for themselves, those workers who are in more insecure work, aren't working excessive hours, aren't doing it without pay, and aren't, rocking up to work sick. But I think, did you want to add in any thoughts on that?
On excess? Yes, and I missed part of your question. I'm sorry, Ms. Fernandez, but essentially we haven't gone into this in detail in our submission. But I would like to put on the record that I do think the National Employment Standards over time should be actively engaging with a reduction in standard working hours. Of course, the labour movement achieved many reductions in standard working hours going back over 150 years now, to the 8-hour day, to then the 40-hour week, codifying the weekend in the 1940s, and then the final time we reduced a standard working week in this country was 1983, when we went to 38 hours. Now, the argument that I have made in other forums, and I'll try to do it quickly here because it's not in our submission, is that as more women have entered the workforce and the average two-income fairly typical heterosexual couple family home now requires two incomes, at least one full-time and one part-time, supposedly, to keep a roof over people's heads, that the hours of work that are needed domestically, the unpaid work that's required to run a household, does not diminish as women enter the workforce in greater numbers and for greater hours. And so actually, having looked at the productivity gains we've achieved since 1983, when we last looked at reducing standard working hours, Australians are actually working longer hours than ever. And so when you combine the number of hours that a household is now working in the paid economy and in the unpaid economy, people simply do not have any more hours to work. Particularly often it's women, primarily it's women that are coming home and taking on that second shift. And so I do think the long-term answer to that is for workers to get some share of those massive productivity gains. We produce in an hour roughly 5 times what we were able to produce when we last reduced working hours in 1983, that those productivity gains should come back in time with no loss of pay. So that's popularly referred to as the 4-day week movement around the world. It can be seen as just a shorter working hours movement. Really, it's not a new idea. It was the foundation of the labour movement in the 19th century, and it is more than past time that we reconsider whether a 38-hour standard working week is the best thing for workers and particularly for families. If everyone worked slightly fewer hours with no loss of pay, the evidence shows that productivity actually can increase, staff turnover can decrease, the costs of things like sick leave and absenteeism go down, and families have more time to divide more equally those domestic unpaid working hours at home as well, leading to benefits for them and, importantly, for their children.
Thank you. I'm just going to ask one cheeky final question.
Thank you so much.
Thanks, Ms. Fernando. Just those reflections, I guess, on the sort of historical context that has led us to this point. And I think in terms of the evidence you have presented in relation to loading not necessarily meeting the requirements of casuals today, and this kind of idea of buying out leave that was established decades ago as a principle. We've heard from other witnesses too around how some assumptions that were made throughout history have really shaped the industrial relation system we have in Australia today. Listening to some of the cohorts as well who are most affected, I guess just invite final reflections in terms of how that history has shaped where we are, who is left out, and what we may need to consider further in making sure that we have, a safety net that actually works for everybody.
Yeah. Well, I will start, and then maybe you can have some final thoughts. But yeah, you're right. The history of the labour movement has shaped where we are today, and that is part of the history of Australia, and part of that is why we end up with these incredibly crucial industries and occupations that are paid less than any other. That is why we've got educators, people who are doing the most important jobs in our economy, who are struggling to put food on the table, and they're women. And the changes to the Fair Work Act in the last government are the first time that we have seen the Fair Work Act actually go, this is about not just male workers, this is about Australian workers, this is about job security, and this is about gender equality. And so if I'm to step a little outside of NES, loving the work of looking back over, our awards, loving the priority review, because it goes, this government, this parliament has decided to make some changes in how we view our labour market, and that has all of these flow-on effects. And that's why I'm so pleased that that the NES inquiry is happening at the moment, because we can say, does the NES, which is meant to support the workers who have the least power in the labour market, and many of them are women, does it ring true to these new objects of the Act to promote job security and gender equality? And so if I can be cheeky, if there's one thing, we make some suggestions of recommendations, there's recommendations across all of the others, but if that is the core driver, does the NES do what we now say the object of the Act is? If that is the one thing I would want this committee to be thinking and have in their mind as you're making recommendations to the Parliament for changes to the NES, because that really is the core of it. Are we promoting a gender equal workforce? Are we promoting a workforce and an Australia where people are in secure jobs?
Thank you, Chair. The Chifley Research Centre is, of course, the official think tank of the Australian Labor Party and the Australian Labor Movement in a way, and we are charged with protecting that history. And so I would reflect that it is absolutely the purpose of the government and of the Labor government in particular to represent the interests of working people and to ensure that they are provided with not just the jobs but the conditions that will enable them to have a good life. If we look back through Australian history, we led the world on the provision of strong workers' rights, right back to the Harvester Judgment over almost 110 years ago now. And that judgment was framed around the concept that a wage should be sufficient to keep, in the parlance of the time, a working man and his wife and family in frugal comfort. What we must continue to do is ensure that the provisions around working rights are fit for the times in which we live, and that's what my colleague's really talking about today, is that people should work to support their lives, not live to support their workplace. And effectively what we see happen when working hours become too long, when rights become conditional, when insecurity and risk becomes a feature of workplaces, is that people's well-being and that of their families and of our society is damaged. So I think taking an historical view allows us to see how much the workplace has changed over time, not just the entrance of women into many more paid hours of work over particularly the last 40 years, but the changing demographics of our country, the changing nature of work itself, a shift from a manufacturing to a care and services-based economy, and now the impact of technology and really deregulated forms of work like gig work. It's absolutely essential that we keep our regulatory and legislative structures up to date with the modern challenges of the workforce, so that we are able to offer young people an opportunity as they enter adulthood to find work that is not just fulfilling and meaningful, but that is adequate to meet the needs of a modern household's demands. And so regular review of these conditions, active shepherding of the system is fundamental to the role of government in a country like Australia. It's one of the reasons that Australia was once known as a working man's paradise, and one of the reasons that we have historically led the world in the achievement of shorter working hours and better working conditions. And so I think this is an important development in that space, and we commend the committee's work and hope that some of our ideas may prove useful to ensuring the NES is fit for the second quarter of the 21st century that we're now in, which makes me feel very old indeed. Thank you.
Well, thank you very much. We're really grateful for your attendance here today and for your submission. You'll be sent a copy of the transcript to request any required corrections to. And enjoy the rest of your Wednesday.
Thank you, Chair.
Thank you.
Thank you.
Just getting stuck to my hair. Excellent. Hello. Good morning. I now welcome Mr. Sean Schmidtke from the Australian Chamber of Commerce and Industry to give evidence. For the Hansard record, would you please state your full name and the capacity in which you appear?
Good morning, members of the committee. My name is Sean Schmidtke. I'm the Head of Workplace Relations Policy at the Australian Chamber of Commerce and Industry.
Thank you. Although the committee does not require you to give evidence under oath, I should advise you that these hearings are formal proceedings of the Parliament. Consequently, they warrant the same respect as proceedings of the Parliament itself. Giving false or misleading evidence is a serious matter and may be regarded as contempt of Parliament. I now invite you to make a brief opening statement before we proceed to discussion.
Thank you very much. The Australian Chamber of Commerce and Industry is grateful for the opportunity to appear before the committee to assist with its inquiry relating to the adequacy of the National Employment Standards. I'm sure you're aware of who ACCI is, but just for the record, ACCI is Australia's largest and most representative voice of business. We are a national organisation underpinned by state and territory chambers right around the country. We're also a peak employer organisation. We have over 80 additional industry association members of ACCI as well. You'll see a sort of pictorial list on page 25 of our submission. But collectively, we represent over 400,000 Australian businesses who, in total, we estimate employ more than 4 million Australians. We have filed a submission dated the 27th of February. I won't go through that in detail, save to note that we made a series of what we would say are sensible and modest recommendations to improve the operation of the National Employment Standards. You could perhaps categorise those as some technical tweaks, but we will say that they will all improve the clarity of how the standards are interpreted, improve usability, and reduce the capacity for workplace disputation. Now, whilst those tweaks are very important, small changes can often make big differences. We haven't called for outright wholesale change, but on the subject of wholesale change, can I just mention that we are aware, or the Chamber is aware, that there are other parties who have appeared before this committee or made submissions to this committee who are calling for quite significant wholesale change, and that includes the changes to ordinary hours of work, additional weeks' leave, and calling for the creation of a range of new entitlements and leave entitlements. Now, it's ACCI's view, most respectfully, that the Commission should reject any of those calls. We say that for a number of reasons. The first is that the Australian Fair Work system and our system of workplace laws is, we would say, one of the most, if not the most, comprehensive in the world. It has recently been described by a University of New South Wales academic as the most progressive set of industrial relations laws on the face of the planet. And that's from an academic that's not necessarily sympathetic to employer views, so that's a big call. Secondly, the National Employment Standards are supposed to act as a base. They are the minimum set of conditions which are applicable at the base level for all Australian workers. They are not designed to be the rolled gold standard. They're designed to be a safety net of minimum terms and conditions. The third reason we'd ask the committee to reject those calls is that, and correct me if I'm wrong, but it is our understanding that one of the priorities of this government is to encourage greater enterprise bargaining, greater levels of enterprise bargaining. There are a range of changes made in the Loopholes Acts 1 and 2, same with the Secure Jobs Better Pay legislation, that were all designed to incentivise and encourage more workplace bargaining to be undertaken. And we note, of course, the introduction recently of the Fair Work legislation amendments, Cooperative Workplaces Bill number 1, which I think was introduced into the Parliament last week. That particular bill at Part 9 contains an exemption for the government in relation to discrimination on the basis of industrial instruments, which the EM says it reflects the government's intention to preference employers who use enterprise agreements and enterprise agreements with particular employee associations. Now, I won't go into the detail of our position on that bill, save and except for mentioning that it is something that we are very, very opposed to in the strongest terms. However, that suggests to me that if it is the intention of the government to encourage enterprise bargaining, one way to do that is have a set of standards which encourages that bargaining to occur. If you continue to add to or create new entitlements under the National Employment Standards, it disincentivises the take-up of enterprise bargaining. I speak to employers on a regular basis, and I can tell you that a lot of them are very resistant to enterprise bargaining, and the basis for that resistance is often that the safety net, the provisions of the Fair Work Act, provisions of industrial awards are very, very comprehensive and increasingly comprehensive, and they don't see any reason to continue the bargaining. So, if there is an intention to pursue that policy, then it's not in the interests to make wholesale major changes to the National Employment Standards, as some have called for. I'll leave my remarks there, but I'm very happy to take any questions the committee might have.
Thank you. Thank you for your submission and for your opening remarks there. We've heard from a number of businesses so far and different organisations as well representing businesses. And something we've heard is that not all businesses are actually familiar with the NES. And so obviously you've got a lot of members. So eager to hear what your membership's understanding is and what outreach and education is provided by ACCI to ensure that people are aware of their obligations?
Well, thank you for that question. So, look, I think it's very hard to generalise about the extent to which businesses have an understanding or otherwise of the National Employment Standards. What I would say, though, is the basics, things like casual employment, things like leave entitlements, things like sick leave, things like long service leave, most people, most businesses, I'd say 99% of businesses are very familiar with. When you go to the Fair Work Ombudsman's website and you look at the basics of employment, they're the sort of key things that come up. And I think most people who've been employees have received those type of entitlements and are familiar with them. In terms of the work that ACCI does, I can indicate that ACCI is a recipient of funding under the Australian Government's Productivity, Education and Training Fund. That is a fund that is run by the Department of Education and Workplace Relations. And with the funding that we get from that particular fund, ACCI undertakes a range of educational activities throughout the country in conjunction with our state and territory chambers. They include things like online webinars, online hubs and websites where people can go and get information. We conduct seminars on a regular basis. We've recently used that funding to roll out quite a significant campaign ensuring employer awareness of upcoming changes to payday super, for example. We're contemplating using that money next round to increase awareness of employers in relation to family and domestic violence leave, and a range of other changes as well. So we do like to think that we use that money efficiently. We do like to think that we target it wherever possible towards those employers that need it most. And it is, I should say, a service that's available, and these types of activities are available to all employers. They don't necessarily have to be a member of ACCI or one of our state chambers. All employers are welcome to attend and access these resources.
Thank you. You mentioned some technical changes that would improve things from your perspective. Something we've heard from a number of witnesses and through submissions has been long service leave and paid parental leave in particular as areas that people would like to see some attention around in terms of some technical changes. What is ACCI's perspective on those particular areas?
With respect to long service leave, we understand that there are differences between the state and territory systems. We think there is some merit, and I think our submission makes a recommendation to the effect that there is a merit in having a discrete review that looks at some of the administrative areas or differences between the way that those particular bits of long service leave legislation operate, with a view to sort of improving some consistency between them. We're not necessarily advocating that there be a national system of long service leave legislation. We need to have something for the states to do, I guess. But what we are saying is that there is some room there to improve, I suppose, the consistency between the legislation relating to the administrative elements of that legislation. In our submission, we make reference to a situation, for example, where an employee had worked, I think, for a very short period of time of some 18 days in Queensland, having worked in other jurisdictions prior to that, but then became entitled to long service leave under the Queensland legislation, whereas they wouldn't have been entitled to it under the other jurisdictions under which they'd worked, even though they'd only been employed for a period of 18 days. So we think a targeted review there is perhaps appropriate, but not necessarily a wholesale review that deals with things like when pro rata long service leave kicks in or the quantum of the entitlement. In relation to paid or parental leave, we do make one recommendation in the submission that goes to the definition of casual. The definition of casual for paid parental leave or parental leave under the NES is different to what's under the Act more broadly. There is a definitional, I suppose, inconsistency there, and we think that there would be room for improvement to make sure that those definitions are consistent. Now, what we said in our submission is that we don't like the existing definition of casual, we don't like the changes that were recently made, and we'd prefer that they be repealed and we go back to the previous definition, which we say was clear, worked well, was known to employers and employees, and there weren't any problems with it. That said, we would encourage definitional consistency.
Thank you. I'll just ask one final question before giving my colleagues an opportunity to ask their questions. We heard from the previous witnesses and we've heard from other witnesses too about the fact that they think that there should be more regular reviews of the National Employment Standards. Do you have a particular view of that? And if so, what would that look like?
I did listen to that question and I thought, what would my answer be where I asked that question? I don't think I reached a conclusion. What I would say, though, is can I say that the business community is to some extent a little bit suffering from review fatigue at the moment.
Okay.
We have the loopholes review underway, there's a wage theft inquiry underway, there's this inquiry underway. We have significant matters in the Fair Work Commission underway, which are either reviewing things like part-time employment, reviewing things like termination, change and redundancy provisions and so on. So there is a lot going on in terms of that review. There are mechanisms available to the government which would perhaps be better than having an automatic review, and that is, for example, the government has the Australian National Workplace Relations Consultative Council, or NWRCC. That is a tripartite group made up of representatives of business, the ACTU and the government. That group is a very good forum where we can have free and frank discussions amongst ourselves about upcoming changes to legislation or issues affecting the workplace. It would be our view, I suppose, that that would be an appropriate forum where if any issues arise with respect to the operation or problems with the NES, they could be raised there and discussed and either solved or perhaps the subject of a discrete review. What we wouldn't want to see is an increasing prevalence, and I'm not blaming the government for this in any way, shape or form. I think it's often independent members of the parliament who build in by default statutory reviews 12 months or 2 years after a bit of law has passed. Those reviews are often premature, perhaps they're very time consuming and aren't necessarily achieving what I think the intended purpose was. So we wouldn't like to see anything like that. Perhaps letting the NWRCC make recommendations is an appropriate way forward.
Great, thank you very much.
Thank you, Chair. And thank you very much, Mr Schmidtke.
Schmidtke, yes, thank you.
For being with us today. I'm wanting to have a talk with you about the maximum weekly hours. You mentioned in your submission that these maximum hours each week can be complex and burdensome. I'm wondering if you could just elaborate on that, and why do you say that, and what should occur instead?
Yeah, so in that context, we refer to the fact that when you work additional hours past that maximum number, there's an ongoing requirement to ensure, from an employer's perspective, that the requirement to work additional hours is reasonable and that it's not unreasonable to get somebody to work additional hours. Now, there are industrial awards that provide for more than 38 hours in terms of roster cycles. There are certain industries which provide for more than 38 hours in terms of common roster cycles. I think, for example, the construction industry, you have a regular 50-hour week. That's sort of over 5.5 days. That's been there for quite some time. The same in the repair services and retail, automotive sector, where you have vehicle salesmen who work 5.5 days a week, or salespeople, I should say, work 5.5 days a week because that's where they make money, is working on weekends. And the requirement for an employer to consistently examine whether or not those additional hours are reasonable, we would say is burdensome in those circumstances where you either have an industrial instrument that provides for it, you have an award that provides for it. The awards are made by the Fair Work Commission. The industrial instruments, such as an EBA, is approved by the Fair Work Commission. And often roster cycles are set in advance, and people are aware of when they're going to be working. And I guess I'm talking in mining, for example. We have fly-in, fly-out people.
So
and
what
again,
would you say is the answer to this?
Well, where an industrial instrument provides for it, where an EBA provides for it, where you have industries where additional hours are a regular feature of the sector, then that requirement to ensure for an employer to ensure that the additional hours are reasonable shouldn't apply in order to reduce that administrative burden.
Thank you. Can I ask another, Chair? I'm also interested in public holidays. You mentioned in your submission about, you suggest that it should be the employee that requests not to work on a public holiday rather than the employer having to ask. I'm interested in hearing more about the rationale for that, but also, as I suppose my immediate thought was, an employee does lack power in the relationship, and for them to have to ask, I wonder whether that could be challenging for an employee, and therefore does it occur, and therefore they don't receive that public holiday. I'm just interested in your thoughts.
Yeah, so the issue here is that you find employers who operate businesses that regularly trade on public holidays. People are employed under a contract of employment that might provide, for example, an annualised salary which incorporates payment in advance for a public holiday, or you have regular rosters that are quite often set monthly in advance that would, for example, roster somebody to work on a public holiday. In those circumstances, we think that it's reasonable for an employer to be able to take action to the effect of rostering somebody on a public holiday, particularly in workforces or industries where it is regular that they do trade on public holidays, or if it's in a contract of employment or some other notice period is given. That's fair and reasonable for employees to basically be prepared to work on the public holiday rather than having the employer say, can we please get you to work on the public holiday? It should be that if they're rostered to work on a public holiday, if it's not reasonable for the employee to work for whatever reason, then they should be the ones to put up their hand to say, look, I can't work on this particular day. I don't think it's very common for there to be any issues once employees are rostered to work on public holidays. And in fact, I think a lot of people, particularly those who are paid according to award conditions, enjoy working on public holidays because of the additional penalties they get. I, for example, am employed under an annualised salary. If I'm asked to work on a public holiday, I know that my contract says it well in advance that I'm paid for additional hours, including working on public holidays where required. So I don't question it.
I just have one final question. It's around AI. It is having an impact in the workplace, and some would argue that it means that the hours of work could potentially be reduced. Interestingly, we just heard from the Chifley Research Centre talking about the 38-hour week, which was introduced in 1983, and yet we have many people working many more hours than that. I'm wondering about the ability of AI to take on tasks that an employee would do, and whether that has any impact you would see in the future on the working week. Interestingly, they're suggesting that we need a 4-day working week.
Excellent question. So, number one, we wouldn't support any changes to the number of ordinary hours down from 38. Number two, we certainly wouldn't accept a 4-day work week. That would require a complete change to the entire underpinnings of the economy. Where a 4-day work weeks have been put in place, they tend to either remain in place for only a very short period of time, or they just simply don't work. And all of the sort of productivity benefits people say come from a 4-day work week, we would contest that. I think you can find any bit of economic evidence, frankly, to point one way or another as to the benefits of a 4-day work week and its impact on productivity. So I don't think that's settled. In terms of the question about AI, I can indicate that ACCI is, and I am part of the government's AI employment and labour market working group. We've met once. And I think we're meeting again quite shortly. That working group has been established to look at things like the impact of AI on employment terms and conditions and the labour market more generally. It's interesting that so far what we understand is that there hasn't necessarily been a negative impact of AI in terms of jobs. There may have been a slowing in the growth rate of certain categories, but it's certainly not. We're not seeing wholesale changes to the jobs that people perform. And in fact, what we're seeing perhaps is I forget the phrase, but it's sort of where people are using AI to sort of assist in their daily job. They're not changing their job per se, but they are relying on AI more and more to get their job done. There's a statistic or a phrase which I wasn't aware of up until recently called shadow use of AI, where people are using AI in the workplace, but they're not necessarily telling their employer. They haven't been directed to use AI in their workplace, but they are using it for tasks where they think that they can get their work done on time. They don't have to stay after hours and things like that. I know I use it for basic sort of documentation, filing. In fact, I find it very useful to track emails down that I can never seem to find. So that's been very useful from my perspective. But I think where I'm going with all of this is to say that we don't necessarily know what the impact is going to be just yet. Now, the good thing about this particular working group, it's underpinned by economists from the Department of Employment. They are looking very closely at employment statistics and changes in the labour market that have been made since 2021, I think it is, when basically ChatGPT became a common feature. So it'd be interesting to see how that all plays out over time. But look, I think generally AI is something that's going to be beneficial for everybody. It's going to benefit workers in terms of getting their jobs done. It certainly benefits me. Certain sectors, I think, will benefit from it. We often hear about it in terms of healthcare. We hear about it in terms of academia and universities. So I think there's going to be significant benefits to lots of workforces. I know that employers are increasingly using AI in a beneficial way from their perspective in order to maximise productivity. We wouldn't want to see AI regulated. We know there's calls for that. But if we are to arrest the significant productivity decline, and it has been a significant decline in labour market productivity in Australia, particularly over the last 10 years, it's basically flatlined. Certain industries have gone backwards. AI will be a way, hopefully, to address that problem.
Thank you.
We've heard a number of different perspectives on productivity. So I've got a question about productivity in relation to a particular concern raised in your submission around the use of medical certificates issued by telehealth or that for personal leave. Something we've heard in evidence and have heard calculations of has been the cost to both the medical profession and others. So thinking about pharmacies, thinking about other places where people can get certificates issued for leave. The cost for workers just trying to get 1 day of personal leave accessed. There have been suggestions that perhaps anything less than 3 days, it should be possible to access that leave without certain kinds of certification. I understand you probably have a different view from your submission, but just wanting to hear a little bit more about that. Again, thinking about the broader productivity impacts on society.
Yes, so it's an excellent question. Our submission on this area deals with this issue of Insta scripts, I think it is. I did actually have a look on a couple of websites this morning about how to generate those Insta scripts. It is pretty easy. You actually have to pay more depending on how many days off you want, which I found to be curious. But nonetheless, I could have sat here at the back of this committee room and put my credit card details in. I've got a medical certificate to have 3 days off, I think, for $69 online, basically by entering a few details. Where we see the problem with this is in circumstances where employers, and I'll be fairly frank here, employers know when people are trying it on in terms of having an absence from work and when it's genuine. Now, I think most industrial awards will say that it's more than 2 days absence before an employer will require some sort of or can ask for some sort of documentation. Most employers don't, I can tell you that. It's only in circumstances where there is some doubt about the veracity or genuineness of the employee having time off that this is a concern, and people are asking for that sort of documentation. We don't think there should be any change to that. What we do say, though, is in relation to things like Insta scripts, there should be a note to say that's not acceptable. We would like people to have some proper meaningful consultation with a registered health practitioner, whether it be online, whether it be even by the telephone or be some other face-to-face method, but actually have that genuine, proper consultation rather than being able to put your credit card details in and get a day off. Now, where we've seen this recently, an example was brought to my attention recently, was an employer here in Victoria who had an employee who was undergoing a disciplinary process. was about to come in for their sort of final meeting, basically to get a third and final warning, and generated or provided this Insta script. It came from a doctor or somewhere in Western Australia. So clearly there hadn't been any proper consultation. So I understand the point the committee is making. We're not asking for any change in this area. We don't think it's necessary to change. I think, to be very frank, the extent to which people do ask for this documentation, it causes workplace disputation. I think it's not actually that common.
Okay, I appreciate those comments. Thank you very much. And thank you for your attendance here today. Really do appreciate it and your submission. You'll be sent a copy of the transcript to request any required corrections. And I advise that the committee will now take a break and the hearing will resume at 11 a.m.
Thank you.
Welcome witnesses for the Union's panel for long service leave to give evidence. For the Hansard record, would you please state your full name and the capacity in which you appear?
Mr Ben Moxham, the Director of Legal and Policy at the Australian Council of Trade Unions.
Thank you.
Mr Matthew Finch, Union Member of the Australasian Meat Industry Employees Union.
Thank you very much. Although the committee does not require you to give evidence under oath, I should advise you that these hearings are formal proceedings of the Parliament. Consequently, they warrant the same respect as proceedings of the Parliament itself. Giving false or misleading evidence is a serious matter and may be regarded as contempt of Parliament. I now invite you to make brief opening statements before we proceed to discussion.
Great, thank you, Chair. Firstly, I acknowledge that we are on the lands of the Wurundjeri Woiwurrung peoples of the Kulin Nations and pay my respects to their elders, past and present. I also acknowledge that the Victorian Parliament, where we are meeting today, is the first jurisdiction in Australia to legislate a treaty with First Nations peoples. Chair and committee members, thank you again for giving the Australian Trade Union Movement the opportunity to speak about the National Employment Standards. Today we just wanted to cover off on three final issues. Firstly, long service leave, which I'll speak about in a moment with Matt Finch from the AMIEU, who has come over from South Australia to be with the committee here today. Secondly, our friends from the Australian Nursing and Midwifery Federation will speak to parental leave, as well as touching on issues around personal and carers leave. And then finally, the SDA and ASU will focus on personal carers leave, but again, touch on some aspects of parental leave. And we're proposing that the committee can ask us questions after our opening statements on each topic. And we're also happy to take any questions on any aspect of the NES if there's any questions left for you guys to ask at this stage. And finally, the ACTU will also file a very, very short submission with the indulgence of this committee by the end of the week on parental leave, which we did not cover in our initial submission, which will give you a bit more detail. On to long service leave. This is an almost uniquely Australian entitlement, and it's a source of national pride. It can give people a once-in-a-lifetime break from work. Think about that trip around Australia where you go with your kids before they're too old to not want to hang out with their parents anymore. Long service leave is also a chance to recharge your batteries, explore a new hobby, lose a bit of weight, do a bit more study, retrain for another job. And if you leave a job you've been dedicated to for a very long period of time, it can be an additional payout that can help you land on your feet to find a new job as well. Unfortunately, the long service leave provisions of the NES are a painful mess and deny too many workers these opportunities that I've just described. I just wanted to walk the committee through why we say it's a painful mess, so please bear with me. Section 113 of the Act effectively requires you to go through 3 steps to figure out what your entitlement is. Firstly, is there a workplace agreement that was in place prior to 2010, so more than 16 years ago, that still applies to your workplace? And the Act says that could be an enterprise agreement, a preserved state award, a workplace determination, a pre-reform certified agreement, a pre-reform Australian Workplace Agreement, an AWA, a Section 170 MX Workplace Relations Act award, or an old IR agreement. You would need to hire a private investigator to figure out if any of these instruments exist, let alone apply to your current workplace. The second test, let's assume the investigator found none of these instruments. The question is, does an award-derived or agreement-derived long service leave term that would have applied to you if you were employed just prior to 2010 exist? And the only real way to know this is to review this 32-page document of pre-reform transition awards or notional agreement preserving state awards, which runs to hundreds, if not thousands, of agreements that are absolutely ancient. Fair Work Australia compiled this. Fair Work Australia no longer exists. It's been replaced by the Fair Work Commission. And it's at pains to say this is an indicative list. It actually does not have a definitive list of all these instruments because it doesn't know. A couple of my favourites, the Dried Vine Fruits Industry Award of 1951 in Western Australia, the Bread Carters Country Award of 1976, also in WA. Most of these awards no longer have any legal force but for this section of the Act, and it's actually impossible to update these awards, no matter how unfair they may seem in 2026. Some of these awards were in place when people had a job for life, and when I say people, mostly men, and casual employment did not exist in this country when some of these awards were first put in place. Some of them also point to outdated provisions of state legislation which no longer exist, meaning that the entitlements are a complete nonsense under some of these instruments. If none of these apply to your employment, congratulations, the relevant state or territory long service leave entitlements now apply, finally. But alas, our fun continues. State or territory leave entitlements have different qualifying periods for long service leave. They have different rates of accrual, different periods of service to be eligible for a pro rata entitlement on termination or early access. Some jurisdictions recognise casual employment for the purposes of long service leave, but they apply different definitions or tests. There are different definitions of continuous employment. Some pay out leave at ordinary time. Some also add penalties, loadings and allowances. And finally, there are different rules around recognising prior service with the same employer, but if you move to a different state. So long service leave, we say, should be as simple to understand as the basic entitlement to 4 weeks, for example, in the NES. Instead, there are hundreds of different entitlements, some almost impossible to determine, many of them highly outdated and deeply unfair. We are on a rare unity ticket with employer organisations in calling for a national long service leave standard to replace this mess. By my count, you've got the Chamber of Commerce in WA, Business Council of Australia, Master Electricians, the Minerals Council of Australia, the Pharmacy Guild, Australian Resources and Energy Employers Association, ACCI, the Human Resources Institute, the Higher Education Institute and the AI Group have all backed reform. So why are we in this situation? The Gillard government had committed to a national standard back in 2010, but this never happened. So Section 113 was always a very short-term sort of band-aid, but this is a festering wound in 16 years in the making. The 2012 review that Ron McCallum ran said there's broad support for a national standard. It didn't happen. The Productivity Commission had a look at this in 2015 and put it in the too hard basket. And here we are 16 years later. I think the blockages around this, for 2 reasons. One is to move to a national standard, you need to harmonise all these complicated existing arrangements. That requires a bit of effort. Secondly, fundamentally, these are mostly state legislated entitlements, so you would need states to make the decision to refer these powers into the Fair Work system. But we say these aren't excuses for more inaction. They're a call for a bit of political will and a sensible way forward. So we're encouraging this committee to call on the Commonwealth and state governments to develop options to achieve a national standard. The first step could be conducting an audit of all those current entitlements I've taken you through, including those prehistoric instruments, to better understand their application, and then think through some options for a national standard. And this could include, a reasonable transition period. We say no worker should go backwards in this process, but we accept employers should have time to adjust. Further, if complete state consensus in building a national standard is too challenging, could we legislate a system that enables states to co-opt into a new national standard when they're ready? And any standard should also recognise and protect the portable long service leave schemes operating successfully in many jurisdictions. And so we say this would be a great legacy of this committee to help finally kickstart this process. We don't underestimate what that challenge would be, but we also say there is a far more immediate problem with long service leave that this committee in the federal parliament could immediately address. So many of these pre-reform agreements and awards leave workers worse off than the state or territory entitlement that would otherwise apply to them. It's not surprising. As I said, many of these agreements were written when workers had a job for life, casual employment didn't even exist. This could be fixed with a couple of sentences in the Fair Work Act. Firstly, to say that a worker will enjoy the state or territory long service leave entitlement if one of these pre-reform instruments would leave them worse off. And secondly, such a change should also recognise the prior service of employees with their employer and not start that clock again. If a pre-reform instrument is better than a state or territory standard, sure, just leave it in place until we can get a proper national standard in place. This would end a profound unfairness, to which I'll now invite Mr Finch to speak about to the committee.
My name is Matthew Finch and I commenced employment in the meat industry in 1996. I've worked my entire life in the meat industry, which has involved labouring, boning, slicing and various works on the slaughter floors. I continue to work in the meat industry today. From 2000 to 2008, I worked at Conroy Small Goods as a casual boner. I then had a short break from Conroy's but returned to work there again as a casual employee owner for a further 8 years between the period 2010 and 2018. I always worked full-time hours. For the entire time that I was a casual employee at Conroy's, I was employed on the Federal Meat Industry Small Goods Award 2000. At the time I was employed at Conroy's, they only employed casual employees and they did not pay long service leave to any casual employees there. I have been a member of the Australasian Meat Industry Employees Union for my entire career, and I was and remain a union delegate member of the Committee of Management and I was later then president of the South Australian branch. When my employment ceased at Conroy's, I was approached by the union to run a test case against Conroy's seeking claim to long service leave on my behalf, and I agreed. The union ran the case and the court initially decided that I was entitled to be paid my long service leave, which meant that I would receive 10.4 weeks of long service leave, or roughly about $10,000. I was obviously very happy with the outcome. Shortly after the first decision, Conroy's appealed the decision to the federal court and they were successful. This meant that despite my lengthy service at Conroy's, because I was employed as a casual on what an old award, that the court decided that I was not entitled to receive any long service leave. I've always been an award covered worker, and while that $10,000 might not seem like a lot of money to the Conroys, it's a lot of money to me. While I don't understand the legal issues, and that's, well, the outcome was unfair, A lot of my colleagues at Conroy's at the time were affected by this court decision because it means that none of them are entitled to long service leave. Thank you for giving me the opportunity to attend today and speak to you.
Thank you for being here and providing us with that personal experience and evidence. We really do appreciate it. It seems like this is a pretty inefficient system as well as an unfair one, in that there's a lot of paperwork, investigation, as you say, to determine what people are entitled to and what obligations from the employer's perspective might be. Given as well, I note the kind of historical nature of some of the awards you've spoken about. Australia is a country where people probably are a bit more mobile now in terms of where they work, and we've heard from witnesses around, people working for the same employer but working across different jurisdictions, state lines. Noting too that some jurisdictions have things like long service leave portability. In all of this, I accept absolutely that federation does provide its own challenges. How would we have a harmonised system or a national system? Like, would the Commonwealth be responsible wholly for this in your perspective as the best level of government to administer? Would it still be something the states were responsible for? Noting again, some states do have provision for long service leave portability. Going again to that principle that no one should be worse off, that was pretty clear in your evidence. Really inviting reflections on what this might look like.
Thank you, Chair. I think there's a couple of options that should really be explored at a sort of an intergovernmental level. I think the cleanest and the simplest would be to treat long service leave like any other entitlement in the NES, that it's a part of the National Employment Standards, it covers national system employers and employees. I think that provides, firstly, a lot of simplicity. I suspect there's significant non-compliance with long service leave entitlements, especially if you're a small business, medium-sized business. How on earth would you navigate what I've described? Secondly, I think it can provide fairness, and any process should really, have a standard that doesn't leave workers worse off, and absolutely supports workers in the same situation as Matt Finch and his colleagues. And that's just one example. We've got more in our written submissions, and the SDA will speak to more. So we think that's the simplest solution. I concede, though, that intergovernmental cooperation is a challenge, and if you're looking, for example, work health and safety or discrimination law, there's actually attempts to, where they couldn't achieve that, come up with a sort of harmonised standard or a model law, which I would describe as a plan B. It's not desirable, but it would be a vast improvement on the current situation that we've got. If you look at all the different factors at the state and territory levels for these entitlements, I don't actually think they're that far apart. They're all just different. And I think with a bit of will, a bit of consensus, you could come up with a transitional system that leaves no worker worse off, but helps employers transition to that process as well. But it needs that consensus building, where I think the Commonwealth needs to take the lead.
And I think, given obviously the complexity that exists, it's probably, very difficult to determine how many people would still be covered by those older arrangements. Did you have a figure, though?
I have no idea.
Yeah.
I won't even take that on notice, because no matter how much time the committee gives us, we will not find out, because there's at least 1,000 instruments here.
Yeah.
There is no data that exists that will tell you who's covered by it, and this is not even a definitive list of instruments. So I think what would be a helpful next step is an audit which gives a rough idea of the coverage and the kind of spread of entitlements, but do that by looking at the state and territory entitlements as well. Some of these instruments, completely exclude casuals, which is just antiquated and harsh, whereas most of the state systems have been updated to include, at least regular and systematic casual employment. But I think that audit would be a helpful tool to try and understand what the picture is, but understand what could a harmonised system look like. So that would help give all parties the information they need to make some informed choices.
And I think, given the nature of long service leave, obviously by definition it's for long service, even if a recommendation, was made, and, in a hypothetical world, all states and territories cooperated and there was a new scheme put in place, there would still be people that would have to be kind of a retrospective examination of people's access to entitlements. As again, it's long service leave, they've been doing this for a long time. So going to your point around transitional arrangements, so what would the consideration from the ACT's perspective be there?
There might be three factors. One is actual time for a new standard to come into effect, so employers get time to adjust. And that might look different depending on the different entitlements people are already on. You might set a standard that already reflects a particular state jurisdiction. Secondly, I think the clock should not have to start again once those rules come into place. So someone in Matt's situation, once the laws come into effect to harmonise, shouldn't then have to wait another 7 years or 10 years. So there should be prior recognition of prior service. I think the third point, which I'd have to actually investigate a bit more, is are there any particularly tricky arrangements between national system and sort of state systems that need to be worked through? Are there any arrangements with particular portable schemes that might need to be worked through? I think that's just detail, though. Once you've got the political will to solve this, that detail should fall into place.
Thank you. Ms. Coker, did you have questions?
Yes, thank you. Firstly, Mr Finch, I just want to say that, your circumstance reflects the fact that casual workers, there are loopholes there, and I take on board what you've said, Mr Moxham, about the need for, was going to be a question around casualisation and the need to include it in any updated long service leave standard. I'm just wondering about practical steps that you think state and federal governments could take to progress this reform?
I think it's the one I put forward. I think get it on the agenda of employment ministers nationally. Number one, do that audit to get a really clear picture of
Yes.
What the entitlements are out there, but also really importantly, what are the gaps? So, there's 2.5 million people on casual work arrangements today. Many of them work full-time hours like Matt and his colleagues, and this is just a blatant loophole that is being used by his former employer. So that sort of audit could realise, just the depth of the unfairness, and I think that could help provide a bit more impetus for reform as well. And then, obviously, those options, we would want something in the NES to be as simple as some of the other entitlements and fair as well. I think there'd need to be, and we're not naive about this, some significant advocacy at state level, and I'm sure with the list of employer organisations I read out, the support of the trade union movement and probably most of your people appearing at this inquiry, that's a powerful force for advocacy to try and build consensus at all levels of government.
Just, can I ask one follow-up question? In regards to workers like Mr Finch who have taken this to through the court system and had no success, if this new system standard was put in place and it did include casualisation, do you feel if a worker is still employed by the same industry or company that there should be some element of retrospectivity about this?
We do. So it goes to the point about making sure the clock doesn't start again. So Mr Finch's case, he's dedicated his entire career to making these employers successful. We think that prior service should be recognised as a part of any sort of transitional arrangements.
Thank you. Well, thank you, Mr Finch.
And I'll just check, we do have members joining us remotely. Were there any questions? I think Ms Fernando, you're on the line.
No, I have no questions. Thank you.
No, thank you. I think we have heard, a lot about the complexity around long service leave, but just to be really clear in terms of the next steps, obviously this will be quite a technical change, but also requiring the cooperation of lots of states and territories. So, this would be a separate process you would envisage to look at this rather than something as a kind of a standard update of the NES.
I think achieving a national standard would have to be a separate process, but a strong recommendation from this committee to kick it off along the lines that we've described, we think would provide a lot of help for that. I think, though, that the committee could absolutely solve Mr Finch's problem with a strong recommendation that says, if these pre-reform instruments do not apply to your workplace, if they leave you worse off than what the South Australian standard currently is, that's a simple tweak to the Act that is just driven by fairness.
Well, it does seem interesting that we do have other tests in industrial relations that are designed to ensure workers aren't left worse off, and would this be one of the sort of anomalies in that regard?
This is probably the biggest anomaly in the Fair Work Act. The Fair Work Act introduced modern awards, which was getting every single award that had been created since Federation and pulling them all together into 100 and 120 much more simplified awards. In the last 16 years, we've been constantly trying to simplify them and improve them. Long service leave is a giant scar across that process because you've still got at least 1,000 instruments, maybe more, that have not gone through that process, precisely because the Gillard government at the time thought this would just be temporary.
Yeah, and on that, and of course we can do some further investigation inquiries ourselves as the committee, but just your understanding of, why in 2010 this was obviously identified as an area that required reform. What's your understanding of the obstacles that prevented that reform from taking place?
I would like to take that on notice because I think it's an interesting historical question. The sort of secondary material we've read is just the ability to get that sort of interstate consensus.
Okay.
But there must be more to the story because the states clearly collaborated and agreed to refer and update a whole lot of industrial powers into the Fair Work Act when it was created. So there's a historic reason why long service leave was left out. We'd be happy to give you a couple of pages that dives into the history a bit more.
Well, we'd appreciate that, and I think we'll do our own research too on that, because I think it is a really important thing for us to remember. Well, if there are no further questions, Ms. Coco, thank you very much for your attendance here today. We really appreciate it, and also, Mr. Finch, appreciate the telling of the personal story in this context. You will be sent a copy of the transcript to request any required corrections. Thank you. We'll get the next panel up as well, which is the Unions Panel for Carers and Parental Leave. I'll give you a moment to set up before we begin the next formal section. I now welcome witnesses for the Unions Panel for Carers and Parental Leave to give evidence. For the Hansard record, would you please state your full name and the capacity in which you appear? So, who'd like to start? Start over here.
Corey, National Industrial Officer, Showing Services Union.
Sue Ann Burnley, Director of Industrial for the Shop Distributive and Allied Employees Association.
Catherine Cannon, SDA member in Victoria.
Alana Ginnivan, Assistant to the Federal Secretary, ANMF.
Paul Euloris, Federal Industrial Officer for the ANMF.
Abby Ainsworth, Delegate from Australian Nursing Midwifery Federation, VIC branch.
Thank you very much. Although the committee does not require you to give evidence under oath, I should advise you that these hearings are formal proceedings of the Parliament. Consequently, they warrant the same respect as proceedings of the Parliament itself. Giving false or misleading evidence is a serious matter and may be regarded as contempt of Parliament. I now invite you to make brief opening statements before we proceed to discussion.
Good morning. Thank you. I would like to start by thanking the Parliamentary Committee for providing the opportunity to speak about the National Employment Standards on behalf of 356,000 ANMF members. By way of introduction, I am Alana Ginnivan, Assistant to the Federal Secretary for the ANMF. I'm also a registered nurse, having worked predominantly in the public health service as emergency and critical care nurse in burns, trauma and neonatal nursing. Today, I'm joined by Abby Ainsworth. Abby is also a registered nurse, but she's also a registered midwife, and she's employed at a major public hospital here in Victoria, in Melbourne. Abby's also a ANMF union delegate and is currently on a short-term secondment with the ANMF VIC branch. And we also have Paul Yularis, one of the senior industrial officers at the Federal Office. So this is ANMF's second appearance at a hearing for this inquiry, having previously spoken about the deficiencies of the shift worker definition. When initially drafting this written submission to the inquiry, the ANMF had done analysis around the deficiency of the National Employment Standards with respect to parental leave provisions. However, we subsequently realised that the terms of reference for this inquiry expressly excluded parental leave and the scope of the review, so this part of our submission was removed prior to filing. We note that some submissions for the inquiry have made recommendations around the Fair Work Act parental leave provisions. Presumably, this was done not realising the confined terms of the terms of reference for this review. In light of this, we wish to put forward our views on the record about how parental leave provisions in the National Employment Standards could be improved. This is an area in which the ANMF has particular interest. The majority of ANMF membership is female, reflecting the highly gendered nature of nursing, midwifery and care professions. In a 2023 study procured by the Fair Work Commission, around gender-based occupational segregation, 8 of the 29 most feminised occupations fell within the coverage of the ANMF, with hospital midwifery at the top of that list. Our members not only provide care to women and parents who need time away from work to care for their newborns and children, but they also need that same access to leave during their own careers. We therefore have 4 recommendations to make to this inquiry. Our first recommendation is in relation to the legislative requirement under Section 67 of the Fair Work Act that a worker must have completed 12 months of service before they can access unpaid parental leave. This is a provision that clearly disadvantages women in the workplace. As it currently stands, a new employee could fall pregnant 2 months into their employment, give birth at the 11-month mark, but fall 1 month short of being able to take unpaid parental leave. So under these circumstances, an employee is entitled to apply for unpaid leave as well as exhaust any other paid leave entitlements they may have accrued, such as their annual leave. However, the employer is under no obligation to grant the employee 12 months of mostly unpaid leave or guarantee a return to their substantive position. This obviously leaves the worker in an impossible situation whereby resignation could be one of the only viable options in order to care for their newborn. Alternatively, they take unpaid parental leave with no job security and face financial instability. This example isn't unique. In fact, it reflects a very real professional and financial dilemma faced by half of the workforce. The objects of the Fair Work Act were amended in 2022 to include the promotion of job security. The 12-month service requirement as a prerequisite to parental leave is incongruous with that objective. Our view is that the Fair Work Act should be amended so that parental leave is accessible from the outset of employment, not conditional upon completion of 12 months of service. Secondly, Section 70 of the Fair Work Act provides only for an unpaid entitlement with respect for parental leave. Where paid parental leave exists, it is often the product of an individual enterprise agreement negotiations and employers setting company policies to match market expectations. Such entitlements do sit alongside the Commonwealth's paid parental leave scheme, which provides a minimum wage payment scheme. The government scheme currently provides payments for a 120-day period, which is set to increase to 130 days on 1 July 2026. The ANMF is of the view that now is the time to move towards the National Employment Standards providing an entitlement to paid parental leave. In terms of shaping this entitlement, we anticipate, of course, that certain factors would need to be contemplated, such as the quantum of paid parental leave, the rate of pay whilst on leave, how such an entitlement should interact with existing Commonwealth paid parental leave scheme, how such an entitlement would interact with existing paid parental leave entitlements under such enterprise agreements, further periods of unpaid leave after paid entitlements are exhausted, whether the entitlement should extend to those employed by small businesses, and whether the entitlement should extend to casual employees, the extent to which partners should also receive access to paid parental leave. In putting this proposal forward, we note first and foremost that it is a bipartisan position in Australian politics that gender pay gap needs to be narrowed, if not closed entirely. We also acknowledge recent efforts made by government to achieve this objective, including extending the Commonwealth paid parental scheme from 120 days to 130 days, requiring that superannuation be paid during these periods of parental leave, and making gender equality an objective of the Fair Work Act. These changes, whilst they are significant, can only go so far. While government can bear some of the cost in relation to paid parental leave, workplaces can and should also play a role in supporting families. If both sides of politics are serious about closing the gender pay gap, then paid parental leave as a workplace right needs to be part of the equation. We recommend that any paid parental leave entitlement under the National Employment Standards should be framed as follows: that the Commonwealth Paid Parental Leave Scheme should continue to operate, and that the employer contribution should operate as a top-up to the worker payments above the minimum wage, that the additional amount from the employer should bring the payments up to the worker's full ordinary rate of pay as opposed to their base rate of pay, that the paid parental leave entitlement should be phased over a reasonable transition period to reach 26 weeks, that workers should be able to take 12 to 24 months off on parental leave, some of which could continue to be guaranteed through unpaid parental leave, that the paid entitlement should apply uniformly to all employers, including small businesses, that the paid entitlement should apply to casual employees or otherwise be reflected through an increase in casual loading, that the paid entitlement should be enjoyed by both parents, and that the employers can continue to compete for worker talent through their enterprise agreement by offering superior paid parental leave provisions on top of the National Employment Standard minimum. In terms of duration, a 26-week paid entitlement would fall significantly short of the 12 to 24-month period that workers currently get as an unpaid leave entitlement under the National Employment Standards. While many employers now offer paid parental leave to supplement the Commonwealth scheme, this is not universal. This is not a universal standard across the country, and there remains pockets of the Australian workforce where there is no paid entitlement available. The practical and real impact of this is that working parents receive a reduction in pay when they take time off to raise their newborns and support families. These are workers who still have rents and mortgages to pay, groceries to buy, and children and families to support. I'll now hand over to Paul.
Our third recommendation is a bit more technical in nature. It's also one that we referred to in our written submission filed in March at paragraphs 46 to 50. Essentially, we are calling for all forms of paid leave under the National Employment Standards to be paid at a worker's full ordinary rate of pay, not their base rate. Our written submission lists a bundle of paid leave entitlements which currently only get paid at a worker's base rate of pay. And this includes a little-known form of leave called paid no-safe job leave. This form of leave is provided under sections 81 and 81A of the Fair Work Act. It requires an employer, first and foremost, to transfer a pregnant employee to an appropriate safe job where it is inadvisable for the worker to continue working in their usual role while pregnant due to the health and safety hazards connected with their role. And where no appropriate safe job exists, that worker can take the awkwardly titled paid no safe job leave. This is an important protection for employees who work in inherently risky environments. Speaking for our members, nurses, midwives, carers, they face the daily risk of occupational violence and aggression from patients, families and other members of the public. Such risks are heightened when the worker is pregnant. I'm sure other unions have members facing similar occupational risks that are inappropriate for pregnant employees to be placed in. This form of leave is essential for our members, but it comes with a massive downside. The rate of pay during this leave is the worker's base rate of pay, meaning that penalty rates, bonuses, loadings and allowances suddenly fall away when the worker is placed on no safe job leave. For many workers, this is a massive pay cut that comes at a point in time when they are usually squirreling away as much money as possible, anticipating that their period of parental leave will barely scrape them through to their return to work on the other side. For shift workers in particular, the difference between their base rate of pay and their full ordinary rate of pay is quite substantial. For them, it represents a core part of their take-home pay and should not be viewed as an added benefit that can be removed without inflicting financial pain on those workers. At its worst, the current provision incentivises pregnant workers putting their unborn babies in harm's way, meaning that those workers are placed in a difficult position to either keep working in a hazardous environment or face a pay cut. Our final recommendation in respect of parental leave is again slightly technical in nature. Similar to the paid no safe job leave, there is a comparable but unpaid leave provision under Section 82A of the Fair Work Act. Unlike the paid entitlement, unpaid no safe job leave seemingly only exists for employees who are not eligible for unpaid parental leave because they have, as my colleague said earlier, not completed the 12-month service with their employer prior to when they would otherwise go on parental leave. These employees still face the same workplace hazards as any other pregnant employee at work. The only difference is that their pay drops to nil when they are placed on no safe job leave because they have not completed 12-month service with their employer. In our first recommendation for parental leave, we called for an end to the requirement for workers needing to complete 12-month service before they become eligible for parental leave. If that 12-month service requirement were dropped, the unpaid no safe job leave provisions would no longer serve any purpose in the National Employment Standards. Our recommendation is that neither should remain in the legislation. If, however, the Parliament is minded to retain a requirement for service to be completed before an employee is eligible for parental leave, then the provisions around no safe job leave should alone be treated as a paid entitlement, irrespective of the employee's service with their employer. So by way of summary, our parental leave recommendations are: 1, parental leave should be made available to all employees, not just those who have completed 12 months service with their employer. 2, parental leave should be a paid entitlement under the Fair Work Act, whereby the employer receives their full rate of pay split between the existing Commonwealth paid parental leave scheme and the remainder topped up by the employer to match the worker's full ordinary rate of pay. 3, paid no safe job leave should be lifted from an employee's base rate of pay to the worker's ordinary rate of pay, along with all other paid leave entitlements under the National Employment Standards. 4, unpaid no safe job leave should cease to exist in the Fair Work Act. At this point, I would like to invite Abby to speak about her experiences of parental leave as both a worker in the public hospital system and as a union rep for her colleagues.
Thank you. Thank you for the opportunity to have me speak to you today about our experiences. As Paul mentioned, I am a nurse and midwife. I'd like to speak to you about 2 points: being a mother and accessing paid parental leave in my workplace, but also as a midwife and the experiences I see from the families I care for. As a mother, I was very fortunate to receive paid parental leave with both my pregnancies. This allowed for me to spend actual time with my babies post-birth to heal, but also to bond, establish feeding, establish a routine, which everyone knows is very hard to do, support newborn growth and development, and build my baby's immune system before I had to return to work. By being able to have that time away, it meant that by the time I was ready to go back to work, my babies were well and safe enough to go to childcare without the worry of missing work because they were completely unwell all the time. We know that children going into childcare, they are at higher risk of, immune system issues. Being around other children, they catch all sorts of bugs and horrible things, and that leads to staff needing more time off. So having that extra time at home with my babies meant that when they did go into childcare, they had enough of an immune system that I was taking less leave, I was a better staff member because I was well rested, my children were in a great routine, and I could be the best staff member that my team needed. Colleagues that I work with have had similar experiences, particularly those that have joined us from overseas and that don't have access to Commonwealth paid parental leave. And that's allowed them to stay in the workforce, whereas alternatively, without this paid parental leave that we have access to, they would have instead considered casualisation in our workforce, which is a huge concern as a female-dominated industry. That brings me to my next point as a nurse and midwife, the concerns that we see. In the hospital that I work in, we care for a largely multicultural and low socioeconomic community, some with quite complex needs. This includes a lot of migrant workers, including people that do not have access to any Commonwealth support. And this means for those people, if they are lucky to be in a workplace that has paid parental leave in their EBA, some of them only have 2 to 4 weeks access to that leave. As a midwife, that's highly concerning when we look at our birth stats reaching almost 50% in some public hospitals for needing a caesarean birth. Now, caesarean birth is a major abdominal surgery, and that takes a minimum 6 weeks to heal, assuming everything goes correct. So how can we allow people to have 6 weeks off work safely when they can't afford it and they need to be back at work within 2 to 4 weeks? We recommend that time off so that they can heal properly and also hopefully bond with their baby. But 6 weeks, I can tell you now, is not an appropriate time to establish feeding supply, routines, growth and development for those babies. And that has lasting impacts on families going forward. So if these people could have access to a bit more paid parental leave, that could not only support them remaining in the workforce, removing that casualisation of the workforce, but long-term could have great impacts on families having good bonding and secure children connections. Thank you.
Thank you very much. We'll do questions for this section and then we'll have some further contributions. So thank you very much for your opening statements and for sharing personal experiences and reflections here. So we've heard from a number of witnesses, as you've noted, and from a range of submissions around there seems to be kind of agreed upon sense that there are inconsistencies that make it very difficult for paid parental leave provisions to be accessed properly. I think something we haven't really heard so much about, and so would really invite your reflections on, is the way that the provisions do or don't support shared caregiving between parents from your perspectives, both as a practitioner but also as representatives of a largely female-dominated union.
Well, look, I'll start by noting that our proposal for paid parental leave is that it should be available to both parents. We know that currently the majority of not only domestic labour but particularly around childbirth and child rearing and early care for children is provided by the mum usually. Our view is that, firstly, that the availability of this entitlement for both parents could encourage further uptake by fathers, for instance, to share the parental load. But I suppose it will ultimately be a debate to be had by the Parliament about how best to actively encourage shared parenting. There are, other models that could be looked to overseas that could be a source of inspiration for the Parliament. So, for example, I know that some Scandinavian countries offer, financial support to both parents equally, and then an additional pool to be made available if both parents have taken the initial first quantity of leave equally themselves. So, an incentive on the end of a parental leave scheme after both parents have put their time forward to care for their children. That is an option that the Parliament, for example, could consider. We're in putting this sort of concept forward, we've deliberately tried not to be too prescriptive because we think there is a worthy discussion to be had about what's the appropriate fit. But that's how I would respond to that particular query.
Thank you. Any observations from practitioners' perspective?
I would say if you wanted to end or reduce that gender pay gap, the first thing we need to do is normalise parenting being both parents' jobs, regardless of gender. And to do that, having paid parental leave for both parents, not secondary, not first, but both parents having equal access, will help change that dramatically. When the second parent has access, it's taken, and I can tell you from personal experience from a lot of my colleagues, it is utilised that way. And I think that benefits, child development enormously to have both parents have that opportunity. I think it would definitely support employees getting back to work and remaining in the workforce because they've got that access. It allows it without having the constraints of childcare fees and ongoing costs associated returning back to work early.
Thank you. And something else we've heard from various witnesses throughout this inquiry has been the fact that you might be on paid parental leave, you might have caring responsibilities for children, but more and more people are having to also care for other family members, older family members in particular. So just inviting reflections on how you think parental leave interacts at the moment, how it could be improved with other kinds of entitlements in the NES, such as carers leave or flexible work arrangements.
Well, I believe we do have items in relation to carers leave, which I think that, you're right, there is considerable overlap. I can't remember if it's in this submission, one of the other ones that we've done lately that refers to the sandwich generation of caregivers, which is the worker typically in their 40s, 50s, or maybe 60s who has either very young children or children still going through school, but then parents who've reached retirement, or ageing but not quite yet in full aged care, and they have to provide care at both ends of the age spectrum, which creates a huge amount of stress on that particular worker while they continue to try and hold down employment. Those workers typically work part-time and therefore have reduced superannuation upon reaching retirement, so it has a huge financial implication on them. We haven't, in terms of how you sort of try and balance that, the idea that we've put forward here is simply in relation to paid parental leave alone. Whilst we have views about the inadequacy of carers leave, that is a separate form of leave, which my view is that these are not necessarily overlapping. Like, you wouldn't use paid parental leave to, for example, provide care for an older person. I think that's a far more complicated scenario. I think I'd rather address that when we come to speaking about carers leave, because our recommendation is an expansion of carers leave, which I think would address that to a certain extent, but wouldn't, for example, provide a full 26 weeks of paid leave to provide care to an older parent.
Ms. Coker.
Yes. Well, thank you all for being here today. as someone who never received any paid parental leave, I think it's an important issue. I'm proud of what the government has done, the federal government, in terms of increasing paid parental leave within the Commonwealth. However, I've got a few questions. So with paid parental leave, do you recommend a minimum period of leave that will be paid? I cannot find something here, but have you got a minimum requirement that you think is acceptable?
So a minimum payment?
Yeah, well, a minimum time frame.
Well, our view is that the full entitlement should be 26 weeks of pay.
Okay. And then has there been any consultation with different sectors? So you're saying that this should be an entitlement for all workers?
Well, we wouldn't have conducted any consultation outside of our own industries and occupations.
Yeah, so within your industry, what's the, I mean, I suppose I think in an ideal world, it would be, this would be an excellent thing. But I also understand the pressures that are on various sectors, such as small business, such as in the health sector or in different industries, that this may not necessarily be seen as something they would embrace. And I'm just trying to understand, like, from your perspective, you know, if government was to implement this, obviously there'd need to be further consultation. But looking at your sector, which is obviously the health sector, and particularly within nurses and midwifery, have you received any anecdotal or feedback on this recommendation of yours?
Sorry, did you?
Well, do you mean...
would they support it?
Yes, there's examples of individual enterprise agreements that have these provisions of paid parental leave, that there's also no requirement to have a 12-month employment engagement, that upon commencing employment you are eligible for paid parental leave. And whilst I absolutely appreciate that it is a different reality for small businesses versus a large public or even private sector, you know, I think the underpinning fundamentals of the inequities of what these primary carers, being, you know, the person bearing the child, is faced. And, you know, to Abby's points around it, not just perpetuates the narrative of it's, you know, the woman's job to stay at home. That is the reality. So whilst, yes, it isn't to say it's common practice, it is absolutely an emerging practice of having no requirement for eligibility for paid parental leave, as well as paid parental leave. But the positive flow on of that also goes to reducing the casualisation, because people, they're not wanting to leave the workforce when they're having a family. If anything, it's you know, the reverse. You need to ensure that you've got that stability. So what we do see is it has the reverse positive of people do have that security. There's not that apprehension, and, you know, they're invested and they're committed to the workforce.
So in relation to, you mentioned earlier about how this would be paid for, you talked about how there would be government then top up from the actual employer. Can you go into more detail about how that could work?
I'm not quite sure what aspect you're asking about.
Well, I'm asking about if someone, obviously, if you're taking paid parental leave, it needs to be paid for. So on what would you suggest would be the structure which that would happen? Would it be the federal government, state government? Would it be the employer? Would it be a combination? What would you suggest?
Well, the proposal is that the federal government continues paying its minimum wage scheme, and the employer makes up the shortfall. So the employer's obligation is only for that top-up amount to the ordinary rate of pay. So
it would be a federal government would take a fair share of those payments?
Well, they already do that.
Yeah, it would remain
the same,
yes.
And then you would have the employer
top up to the ordinary rate. Yes.
Yeah. No, thank you.
Yes.
It's good for me to get
because
that.
like Paul and Abby may have mentioned, with shift workers, and you rely upon those extra, the night shift, the weekends, and it's deemed as a top up, but that's your take home. So by having the employer top up the difference to your ordinary rate, it means that you're not going, the award, it's not to say there's obviously been significant and recent increases to the minimum wage, but yes, the ask would be that the Commonwealth remains paying the award minimum with the top up by the employer to the individual's ordinary rate of pay.
Okay.
If I could just make a supplementary point, and this
Yes.
goes to your earlier comment or rather query about whether or not employers would support any such proposal. One of the suggestions that my colleague made was that that moving to a shared paid parental leave system whereby government continues to pay a portion of the leave entitlement and the employer pays the supplementary amount, reaching ultimately a goal of 26 weeks full pay for workers. Our proposal is that should be phased over a reasonable transition period rather than something that is an instantaneous change that happens overnight through legislation, because approaching it that way could be quite a shock to the system, whereas a phased approach would allow for the necessary workforce and financial planning to implement such a system. And this is not sort of unheard of in the industrial space. By way of example, superannuation contributions did not go from 9% to 12% overnight. They were ratcheted up by, I think, 0.5 percentage points over a number of years to reach the goal, the end goal of 12% as it currently stands. We think a similar approach in respect of paid parental leave under such a model would be the preferable way to go about it.
And
Yeah, one more.
very quickly, you also say that there should not be a minimum period of service required to qualify for paid parental leave. So, would you say that if someone joins in a job and they're only there for a month, that they should still get that entitlement? Or should it be a longer period? Should there be any ability for, for a person to be there for a longer period before they get paid parental leave? Or if they're only, say, for example, there for a month, and they should still be entitled to that paid parental leave?
I said you wanted to.
Oh, sorry.
Short answer is yes, we think it should be available from our position is from the outset of employment.
Yep, okay.
Yes.
I'm not disagreeing with you. I'm just interested in your views. I am a very, very supportive of paid parental leave. I just, it's just how we make it work is the most important thing.
And I think the other, when someone falls pregnant, again, it's not an instantaneous. Yes, they may join and be at that employer for a month, as you've mentioned, but it doesn't mean that the next day they're leaving. They're still going to be contributing to that workforce for a significant, not significant, but a period of time, and then the ideal scenario being able to return. So it isn't about again, I think it is. I can say it's pie in the sky thinking, but yes, I think it should be an option that is available, that you join and you have that security, that you don't have to walk into work or go to an interview and think, what am I going to do? And, how many women are faced with that reality, not having that sense of security, or having to, it's that taboo and the secrecy of, perpetuating that narrative that it's an, imposition on me as a person, that if I choose to have a child and I'm changing for whatever reason it may be, I'm changing my employment, that that's not an option available to me. So yes, we would strongly support that it would be available to at the commencement of employment.
Okay, thank you very much. Really appreciate your contributions, and we've got some more opening statements to hear and a discussion to have around carers' leave.
Yes, so thank you, Chair. Yesterday, thanks to the committee for this second opportunity to come and speak before you. We are here to talk about personal leave and carers' leave. They intertwined between the two. I would, however, with indulgence, just make a brief comment regarding the long service leave matter that you heard of previously. We did put into our submission an example of somebody who'd worked for 21 years as a casual, 3 shifts per week for most of that time, regularly employed. And because she was employed under the award called the Vehicle Industry Repair Services and Retail Long Service Leave Award 1977, it denies casuals long service leave. Before award modernisation, we had been able to convince some employers that they had to pay casuals because it said it was excluded, so therefore, if you're not covered by the award, therefore you've got to go on the state legislation. The courts have found otherwise in their very legalistic approach to it. So this member that we had, and it's not an irregular occurrence that we get these days because most of this industry is based on casual employment because it's cheaper. There are long-term employees working there who do not realise that they're not entitled to long service leave until it comes, and then they find out off us we can't convince the employer, to pay anything as for their dedicated service, which is such a pity. So we think that since award modernisation in 2008, there was an undertaking or a feeling that we were going to be able to work through the long service leave harmonisation with all the states, territories and federal government. So therefore there was this protected set of awards. Long service leave awards couldn't be touched, still can't be touched, still can't be changed, and employees are trapped on them. So we're saying that 18 years on, it's long enough for them to have been sitting there, that employees should be allowed to get out of that system if the state legislation provides otherwise. So yes, it's good to have the long-term objective, might be another 20 years, to get harmonisation of long service leave provisions, but to get employees out of those systems where we, as unions and employees, can't change those awards under the Fair Work Commission system. We haven't been given that right to do that, so we're stuck. Even though it says reserve matters, reserve matters, reserve matters, we can't readdress them. So we think that as a short-term solution, something needs to be done to change that part, because it is one of the rare parts of the award system that is sacred for some particular reason. So we think that 18 years we should change that simply without waiting for the rest of the nationwide long service leave, because I'm sure I'll be finished work before that happens, but we'll see. So I'm appearing here today with member Cathy Cannon, who's a long-term worker in the retail industry, so she'll be able to speak and reflect on the voices of our members who deal with carers and personal responsibilities as such. As we all know, the entitlement to paid personal and carers leave is 10 days, and it's pro rata for part-timers, for which there are a majority of workers in our industry who are part-time, and there are some who are casuals who don't get paid carers leave at all. They get unpaid carers leave if they need it. What we say is that there are a number of issues regarding this, as it is in the NES from 2008, and we put these in our report. And the first one is that personal leave should be paid at the full rate and not at the ordinary rate of pay, because many of our workers do work now on evenings and weekends where there are penalty rates. So for them, they miss out when they take carers leave to care for somebody or they're sick. Their pay drops for that period of time. So they've got to make a choice sometimes as to whether they want to bear the financial responsibility themselves because they've chosen to work, well, maybe not chosen to work on weekends, because they get a higher rate of pay. But as soon as they get sick, the rate falls for that period of time. The second point is that we would like this also to be for significant others. At the moment, it's a limited category of workers that is covered by carers leave. And we call this significant others because, depending on the family situation or your individual situation, significant is different in each case as to what it is. There's kinship relations, there's cultural relations, there's extended family, there's in-laws, outlaws, etc. That, there might be your next-door neighbour that you live next to for 20 years and you've built up a kinship relationship with them. So we think that there should be an extension, as per our submission regarding significant others, to be recognised for the purposes of carers leave. Extended unpaid leave for workers who have a need to take care of somebody who has a long-term illness or a disability. We detail that also. So this would allow a worker to have a right to say, I need to go look after X because they've got 6 months of this illness or in palliative care. And and they need to have that right so that they can put on hold their job and then continue working when they come back. And the other point that we've got in our submission is to do with grandparent leave and the recognition that the role of grandparents have. So as I've said, that penalty rates we lose out on, our members do, when they take leave, so we think that this should be changed so that on personal and carers leave, penalty rates are included when you take that leave, so there isn't a financial risk in taking your leave, and this we think is an economic benefit for the economy as well, because it's not the worker bearing the financial disadvantage. We think that there should be some more leave available as well. 10 days is shared between either personal leave or carers leave, so at times you've got to make that choice. Do I take it to look after the children, or do I save it because I know I need it in the future because it's flu season coming and I'm probably going to get sick and need it? So what is my choice being made there? So we think either increasing that amount, in past agreements we've had up to 11 days. We had 10 days, we had 8 days of personal sick leave and then 3 days of paid family leave. With the new system came in place, it got reduced down to 10 in most circumstances. So we think extra leave, either as a bundle or a separation, to say there's carers and there's personal leave, or you can mix and match, however you want to take it, depending on your situation. Since 2008, as we know, the modern workforce has changed still and still evolving, so we think that this needs to be addressed in the NES so that the realities of how people live their lives, how they work, is taken into account. There is a lot of informal care now in the workforce because there is, as we know, there's the sandwich generation, looking after the elderly, looking after the school age and looking after the babies and everything else that falls, unfortunately still falls mainly on women to balance all of that out. So we think that there should be some change made so that the realities of people's working lives and living lives are captured appropriately. So on the issue of what is covered or who is covered by this, we do have examples where people have looked after their aunts taking carers leave, and then they've also looked after their next door neighbour that's lived next to them for 20 years and they were doing caring responsibilities. At times, the employers come along and say, aunt is not covered by the definition of carers. You need to take your annual leave if you want to continue caring. So after doing it for 3 years using carers leave, the worker had to make the choice then and had to take annual leave to cover it. So we think that a change to the definition is required. Most people are not going to abuse it. They have genuine concerns and genuine needs. We think also that grandparents are becoming more likely to be primary carers in some situations, and it might not be informal care, might be looking after children after school, etc. So we think that there should be some policy reform that explicitly supports grandparents for grandchildren, and it's not just an exception or an incidental matter. It might be a regular caring relationship that they've got, so it's after school care, because there isn't affordable childcare available for the after school care programs that exist. So grandparents should have an explicit recognition that they do play a fundamental role in society. So you might be aware that the SDA has been heavily involved in personal and carers leave, and so there's been a couple of inquiries, and there was a parliamentary inquiry into who cares conducted over the last few years, and prior to that the SDA had a worker level research which demonstrated that the current workplace settings impose direct financial penalties on employers who undertake caring responsibilities. The Parliament Who Cares report established the carers already experience heightened financial stress and reduced workforce participation due to the demands of unpaid care and inadequate support system. And this is then compounded by the payment settings within the workplace where they miss out on penalties. The SDA's report, Who Cares, shows that in our industries of retail and fast food and warehousing, that there is a lot of work which is structured around non-standard hours, the 9 to 5 Monday to Friday, which includes a lot of evening and weekend works, which is paid at penalty and premiums usually. And these workers have limited access to flexibility and often have to forego their income due to the employer-driven rostering practices. So without the penalty ordinary rates being paid, if they're relying on those loadings, they do suffer a material reduction when they take the leave on weekends. And this was evidenced in the SDA surveys, so that it exacerbates the stress and the financial stresses that their workers are facing at the time, because it is a detriment to their income when they take those leaves, and undermines whether they actually do take the leave if they're forced to choose. And we do have stories that they leave their children unattended at home to go to work. So we think that in these industries which have got shift penalties and are low paid, there needs to be some addressing of this issue now, so that employers can have their rights, which is to take the leave and to provide the care, but it needs to be protected, because at the moment it creates a systematic disincentive to take the leave, and there is that. And in these two reports, there's an evidence of the gap between formal entitlement and real-world access to the leave. So we think that economically and socially that it is rational that we now improve this leave by the recommendations that we've made, which would then have productivity and social equity benefits, especially to female workers and young workers in the workforce, because we believe that that the current carers leave and personal leave settings were set at when there was different labour market settings, and there was a narrower understanding of family. It's now broadened, so we think that there is reform required to ensure workers can care for others without financial penalty, and that the law reflects how care is actually provided in the modern Australian workforce. I'll now turn to Kathy, who can provide and give some voice from our members directly.
Thank you. Thank you for having me. I'm Catherine Cannon. I work at Officeworks in Narre Warren. I've been there for 18 and a half years. I'm now part-time permanently employed by them, and recently in the last 5 years, I had to take over caring for my step-granddaughter. Her mother had problems, and the court elected me to be her full-time carer. I was working 25 hours a week. I worked sort of night shift. It's like 4 o'clock till 9 o'clock, but you get penalty rates. I unfortunately had to give that up because there was no one to look after her in those hours. So during the day was fine. She was at daycare. They helped me out there. But, it was very hard, along with the stresses of what the mum was going through and putting, the daughter and myself through, the granddaughter and myself. I used up holidays, my personal leave, my carer's leave. I ended up sick. Of course, she got the normal things that young kids get. And, I ended up using long service leave. So I'm lucky I've been employed for that long to have long service leave. And moving forward a couple of years, she's now back with her mum and everything's happy, thank goodness. Moving forward a couple of years, my parents are now elderly. They're actually both 87. So, I'm moving into that space now of looking after them and taking care of them. So, once again, that carer's leave and personal leave gets used up pretty quickly with appointments, medical, having to stay home with them if there's something wrong and that sort of thing. So, I just wanted to let you know how it is, As I say, you end up using your long service leave, so it's quite hard.
Thank you for sharing that. We're very grateful, and we'll have some further discussion in a moment, but we'll hear from...
Thank you, Chair. Thank you for the opportunity to appear today on behalf of the Australian Services Union. Today, I will address a gap in the NES related to unpaid parental leave and carers leave, and how that gap reflects a broader issue. Our workplace laws have not kept pace with the reality of modern families involving foster care, permanent care and kinship care. And today, I speak from personal experience. I'm a parent of two. I have a biological daughter and I have a son via a permanent care order. My son is not biologically related to me, but in every meaningful sense, they are both my children and they are loved. Yet the law does not treat them equally. The inequity starts at the point in which the child enters a family, and it begins with parental leave. When my daughter was born, there was no ambiguity. I had a clear entitlement to parental leave, to care for her, to establish a bond, and to provide stability from the outset. But that clarity did not exist when my son came into my family. When he first entered my care, there was no clear entitlement to unpaid parental leave. At that exact point, where stability, consistency and care was most critical, the law did not recognise his need for me to be present. That is a fundamental gap. Children entering foster care and kinship care are often experiencing disruption and trauma. The early stages of care are critical, and this is when trust is built and stability is created. Yet, the national employment standards do not clearly extend unpaid parental leave to foster care, permanent care and kinship arrangements. Carers are left to navigate uncertainty or rely on employer discretion rather than being supported by a clear entitlement. That inequity does not stop there, and it continues in how carers leave is defined and applied. Carers leave depends on whether a child is recognised as a part of the employee's immediate family or household. The Act recognises biological children, adopted children and stepchildren. However, foster children are not expressly mentioned, and they're only indirectly captured by the concept of a household member. That leaves a very narrow test, whether the child ordinarily resides with an employee at a particular time, and that creates uncertainty. My entitlement to care for my daughter was clear from the outset. For my son, particularly in the early stages during care and during transitions, that depends on a technical definition and not the reality of the caring relationship, and that's very inconsistent. There are two practical examples of how the narrow framework continues. My mum can take carers leave to look after my daughter without question, as that meets the family definition. But that same clarity does not extend to her looking after my son, as by definition, he is not immediate family and he does not reside with her. So even though they share a loving grandmother and grandson relationship, they are not captured by that. This not only exposes the gap, but leaves an unacceptable risk for vulnerable children. The second is that my daughter will remain recognised for care purposes as she moves into adulthood. However, for my son, as he moves into adulthood and out of the home, that recognition will fall away because he will no longer be a part of my immediate household. So two children, siblings, raised in the same family and supported by the same people are treated very differently. And that's not because of the care that they receive, that is because of the way the law classifies the relationship. So in practice, many carers perform the role of parents. That responsibility doesn't turn on labels, legal labels, or moment-in-time living arrangements. So there are two clear reforms advanced by the ASU. Firstly, unpaid parental leave should be expressly extended to include foster care, permanent care and kinship arrangement where there's a test of permanency or long-term placement. So carers and children can have some certainty when that child enters that family setting. Secondly, for carers leave, the law should reflect a simple principle and that is, does the employee have a genuine caring responsibility? And in my particular evidence, an immediate fix would be to extend the definition of child in the NES to include foster children and children of whom an employee has recognised care responsibilities. So if someone is trusted to care for a child, to provide love, stability, support at those most critical moments, then that relationship should be recognised from the outset and for life. Thank you, Committee.
Thank you very much. We really appreciate all of your contributions. I'll start with a question, and I think we've got Ms Fernando joining us remotely. We've got the speakers here. Oh, sorry. Yeah.
We had a couple of extra comments to make on personal carers leave.
Oh, sorry. My apologies. Yep. Certainly. So I wasn't aware of that. Thank you. Yep.
Okay, thank you. Our written submission at paragraphs 51 to 57 made a recommendation for an expansion of personal carers leave, sometimes referred to as sick leave. For clarity, and I believe the SDA mentioned this, personal and carers leave come from the same pool of 10 days leave per annum. One of the fundamental problems in our view with the personal and carers leave provisions is that it operates narrowly to focus on reacting to ill health and injury rather than encouraging workers to maintain good health. In our view, the focus should be shifted to preventative health care, and workers should be supported to take necessary steps to keep themselves, their families and their households healthy. Under the National Employment Standards, for a worker to take personal leave, they need to be unfit for work. This means that a worker technically cannot use their personal leave to attend medical appointments unless they are also unfit for work at the same time. This is entirely inadequate because not all medical issues requiring medical attention are such that an employee is rendered unfit for work. For example, an employee with a mental health condition may be able to continue attending work despite their medical condition, but it would be preferable for that worker to continue attending regular appointments with their psychologist or therapist. They should not need their condition to deteriorate to the point of incapacity before they are given the paid time to attend to their own healthcare needs. For workers who have chronic health issues such as diabetes, this kind of flexibility in being able to take time off to attend appointments is vital to managing their complex health needs. Workers often don't have control over the availability of appointment times, which sometimes clash with working hours. It's not always possible to schedule a medical appointment to fit neatly into a work break or outside of a shift. For workers with caring responsibilities, the narrow framing of personal and carers leave is even more complicated. These workers often exhaust their leave balances providing care for others with little left over for themselves. Many of the issues for personal and sick leave persist in the case of carers leave. For example, a parent wanting to take their child to the dentist or to go get a flu shot cannot use their personal or carers leave for this purpose because the legislation requires the child to have an illness, injury or some other emergency situation arising as a prerequisite. Our written submission recommended two alternate options to fix this. One is that Section 97, of the Fair Work Act be amended to permit the use of personal and carers leave for medical and other healthcare appointments, combined with an increase to the overall quantum of leave, or alternatively, that the National Employment Standards be amended to include a new separate paid entitlement to allow employees to attend medical appointments without workers or their dependents needing to be unfit for work as a prerequisite. The ACTU and other union affiliates may have views about the merits of either approach. In either case, what we do not want to see is a situation where workers either continue under the status quo or that the existing 10 days leave remain in place, with the only change being that they can use the same 10-day balance of leave to attend medical appointments. As we say in our written submission, simply allowing workers to use their existing 10-day entitlement for medical appointments could deplete the entitlement for medical appointments that might be needed for future health, family or a household crisis. Or alternatively, a worker might just simply hold off using their 10 days personal or carers leave for preventative healthcare appointments to save it up for some rainy day and in doing so neglecting their ongoing health needs. All of this reinforces, in our view, the need for an expanded entitlement, both in terms of the amount of leave and its permitted uses. And again, I'll invite Abby to speak about some of her experiences navigating the personal and carers leave space.
So from this perspective, I have two anecdotes for you. So for myself, I have formerly been diagnosed with ADHD, as many of my healthcare clinicians unfortunately have as well. So for me, I regularly attend a psychiatrist, and that's to be provided with medication and discuss therapies and make sure that they're implemented so that I can be the best person I am. My psychiatrist is on average a 4-month wait to book in. I do not get my roster that far in advance, but unfortunately the roster provisions generally close by that point so that they can be created. So I can't request time off in advance to book that, so I'm not impacting my work, and I just have to hope that I have a day off or swap my shift. Now, swapping a shift is not always easy. For clinicians, there's quite a large system we need to go through to make sure that we have adequate staffing and safe staffing. So quite often that leaves me with a position of taking personal leave, being able to use it in the public sector EBA. We have that provision where we can access personal leave for appointments for preventative health. For me, that means I'm not giving up paid time to go to these appointments. It means that I'm staying well and staying in the workforce. The downside is that I don't receive penalties if I've taken that day off with personal leave. For nurses and midwives, that makes up a substantive amount of our wages. Over 30% of my wage would be in penalties alone. So I have to be really mindful if I'm going to miss out on that. My second point is my child, using that leave for my child. So one of my children, my little boy, has sensorineural hearing loss, which is congenital hearing loss, and he's currently undergoing some further testing to find the exact cause from it. His appointments are quite difficult to achieve around working hours and school hours, and because of his age, we need to generally get appointments first thing in the morning for accurate diagnosis and management. So having that access to personal leave for his appointments where he is well and he can attend his normal duties, I can attend my normal duties, but I need to take him to those appointments. It's meant that my workplace has supported me completing half shifts, so still attending some of the shift and still being part of the team, but having the ability to take him to his appointment, getting those needs met, sending him off to school. It means that I'm not trying to pick up extra shifts to make up that time that I've missed. It means that I'm not having to do double shifts to try and make up the penalties I've missed. It means better work-life balance. It means I can be a better parent. It also means, though, for the workplace, I have the time then on days off where I can offer to work extra shifts when they are desperate. And I can tell you in the healthcare system, that is every day, every shift. Thank you.
Thank you for that contribution. And now, so we will go to questions and discussion. Now we can we're running a bit over time, but I hope it's okay if we can just spend a few minutes on some questions. The issue of foster caring has come up and kinship care has come up in this inquiry before, and there have been a number of suggestions around how we can provide for the care required in the NES, and so I really appreciate hearing your story today very much. One suggestion that was put forward, and just inviting reflections here, is that foster caring may be able to be part of the community service leave provision as an additional kind of access to additional time, in the same way that if you were going to volunteer for the CFA, etc., you may be able to access that additional leave. So what would your thoughts be about that way of approaching this?
Respectfully, I disagree.
Okay, yep.
I don't think it supports the concept of family.
Yep.
And what's really important for vulnerable children is ensuring that there's a system that supports them being a part of a family. It's not a community service, it's about the family unit and supporting that child through their vulnerable stage.
Yeah, so for you, the definition, as you said, the definition and making sure that, you know, there's more access to time is really what is required.
That's correct, Chair.
Yeah, so just for the evidence for the hands, that's
Yeah.
clarifying. Thank you very much. I think Ms. Fernando's got a question, then we'll go to you, Ms. Coker. Ms. Fernando, I believe you're still on the line.
Hi, Chair. Thank you so much. So one of the questions that I have, and thank you so much for being... Can you hear me?
We can now. Thank you.
Sorry. Thank you so much to all the witnesses and the unions being present this afternoon. So one of the questions that I have is, what are the main gaps in the current leave framework for people with caring responsibilities across their working life? That's one question that I had.
Was that directed to anyone in particular, Ms. Fernando, or is it an invitation for...
anyone can answer that because it's a general question.
Okay.
My apologies, Chair. The sound was a bit shaky. Would you mind perhaps,
I've got the question.
if you are able to sort of understand it, it would be helpful for us.
Yep. The question is, what are the main gaps in the current leave framework for people with caring responsibilities across their working life?
Yes, some of the gaps which are in there which have been identified is the definitional issues, which goes to the foster, permanent care orders, your extended family, the kinship family, the cultural families, other people that you've had associations with over your lifetime, that you've had a close caring relationship, so they are like family, but not. There's also a concept floating around such as found family, so that if you don't know who your parents are or you're separated, you're separated from your...
Appropriate contribution.
Absolutely, absolutely. We need to look after those ones. So, you know, so if you're isolated for whatever reason from your real family, you develop other relationships which technically aren't family but should be family, recognised as family.
Thank you.
I think to add to those comments and to Corey's around, you know, the definition and you know, the comments that having a foster child isn't community service, but also around the definition of being unfit for work to be able to access personal leave, that you know, that expands to those definitions.
And I guess as well that flow-on effect that talking about, particularly with that sandwich generation, or parents, grandparents looking after children, that becomes more important to accessing different kinds of leave from what I've heard.
Yes. I just have one question. We've talked about carers' leave. There's been some different suggestions about improvements that we could make. What would be the one single most effective change out of everything we've discussed today that would improve the life of somebody who's caring for another in employment?
Hard to put it down as just one. I mean, you know, don't know which one.
I'll be a bit cheeky, if you don't mind, committee member. I think there's two, and one is that the appropriate test is a test of a caring responsibility to capture the circumstances that we've presented to you today, but as also an immediate fix, because acts generally require definitions. For my purposes and the purposes of our SDA member today, is ensuring that the definition of child is extended to include foster and the other arrangements that have been discussed.
Okay, thank you. Any other comments?
I'd like to be a little more blunt and just say more leave is probably the single biggest fix. But when I say that, I do so with a qualification, which is that we've clearly, I think, highlighted a number of scenarios which are simply not captured by the current restricted definitions. So it would be more leave, but contemplating that there are all these other scenarios where the leave arrangements simply don't capture what people actually need personal and carers leave for.
Okay, thank you.
The SDA would be the penalty rate issue.
What was that, sorry?
It would be the penalty rate issue, not being
Okay.
paid the penalty rates on it, which causes the financial stress to our members.
Yeah.
We'd also like to change the definition as well, as take number 2.
All right, thank you very much.
No, thank you. And we really appreciate everyone's contributions and people sharing their personal stories. It's not always easy or natural to do that. So we are very grateful for your generosity and to assist us in our deliberations to make recommendations. So thank you. I've got to do my final little formal bit now. Gosh, I've lost my page. There we go. Thank you for your attendance here today. You'll be sent a copy of the transcript to request any required corrections. And I advise that the committee will now take a break and the hearing will resume at 1:30 p.m. Thank you, everyone. to Mr. Paul Gibson from Indigenous Allied Health Australia to give evidence. For the Hansard record, would you please state your full name and the capacity in which you appear?
Paul Gibson, representing as the Chief Operating Officer for Indigenous Allied Health Australia.
Thank you very much. Just because we're online, I'll introduce myself as Karina Garland, the Chair of this committee, and I'm here with Ms Coker, the member for Corangamite. Though the committee does not require you to give evidence under oath, I should advise you that these hearings are formal proceedings of the Parliament. Consequently, they warrant the same respect as proceedings of the Parliament itself. Giving false or misleading evidence is a serious matter and may be regarded as contempt of Parliament. And I now invite you to make a brief opening statement before we proceed to discussion.
Thank you, Chair, and thank you to the committee for the invitation to appear. Firstly, I'd like to acknowledge the traditional custodians of the land on which we're on this meeting. Pay respect to elders past and present. Today I joined from Kaurna country in Adelaide, but also acknowledge Ngambri people of the ACT, where I normally live and work. As mentioned, my name is Paul Gibson, Chief Operating Officer, and I'll be here on behalf of Indigenous Allied Health Australia. IHAR is a national, Aboriginal and Torres Strait Islander community-controlled and member-based organisation. We have approximately 2,300 members nationally. We are the peak body for the Aboriginal and Torres Strait Islander allied workforce across Australia. Our work centres on education, training, workforce development and leadership, supporting our members to lead change in health and wellbeing systems, grounded in Aboriginal and Torres Strait Islander ways of knowing, being and doing. I want to be transparent with the committee at the outset. IHAR is not an industrial relations organisation. We do not hold deep technical expertise in employment law. We attended the committee's invitation today because we believe that IHAR does have something genuine and important to offer this inquiry. That is, our direct experience of what employment conditions mean in practice for the Aboriginal and Torres Strait Islander workforce, our families and communities. Our submission centres around a core concept that the National Employment Standards should be understood not only as a set of industrial entitlements, but as foundational legislative infrastructure that shapes economic participation, workforce sustainability and social inclusion across Australia. How these standards are designed and whether they reflect the realities of all workers have consequences well beyond any single enterprise or sector. From our perspective, three things are of relevance to this inquiry and the work of the committee. First, the NES must be assessed against Australia's binding commitments under the National Agreement on Closing the Gap. Priority Reform 3 requires governments to transform mainstream systems so that they operate in culturally safe, inclusive and accountable ways. Employment law is a whole of society system. Closing the Gap Outcome 8 seeks to increase the proportion of Aboriginal and Torres Strait Islander people in employment. But employment must be sustainable and secure if it is to support wellbeing, income stability and social inclusion. The NES cannot be understood in isolation from these obligations. Second, where employment standards fail to reflect the lived realities of the Aboriginal and Torres Strait Islander workforce, including diverse kinship structures, cultural and community obligations, and the realities of the regional and remote labour markets, workers can be placed in untenable positions. They can be forced to choose between cultural responsibilities and secure employment, or push themselves to meet the needs of both. Our submission identifies two illustrative reform pathways: modernising the definition of immediate family and embedding formal recognition of cultural leave, not as prescriptive drafting proposals, but as examples of how the principles of inclusion and cultural safety could be embedded within the NES or related frameworks. Third, we feel that inclusive employment standards are not only equity measures, they are also workforce and productivity measures. IHAR's experience in workforce development demonstrates that culturally safe and inclusive employment environments improve retention, reduce turnover, and support continuity of service delivery, particularly in regional and remote communities where workforce shortages are most acute. We look forward to the committee's questions and to contributing to an inquiry that we hope will improve employment standards that will result in employment standards that work for all Australians. Thank you.
Thank you very much for those opening comments. Really appreciate that and your appearance today. So I think I'll begin with some questions, and Ms. Coker, who's here, may have her own as well, so throw to her in a moment. Something that has come up quite a bit in relation to the National Employment Standards, and as you raise, has been the definition of family, of kin, and who is then able to access and provide care. So I think what would be helpful to draw some of this out for the committee today would be some of the practical consequences when kinship obligations aren't recognised, and if there are examples of how we can improve the definition of family and of kin.
Yes, thank you for the question. I think our submission and my comments sort of reflect a higher level pathway of how the definition could be modernised as opposed to being able to provide too prescriptive recommendation around the drafting of immediate family. But what we can say is that the current definition reflects predominantly the sort of nuclear family assumption. So we say that it doesn't reflect the kinship system and extended family obligations that are central to the lives of many Aboriginal and Torres Strait Islander people. A modernised definition could better reflect contemporary family diversity, including that extended kinship relationships and community obligations, and reduce the reliance on sort of informal or discretionary employer accommodation in these circumstances that currently produce inconsistent and inequitable outcomes. Our experience sort of shows that when it is at the discretion of employers, it's inconsistently and inadequately provided as recognition of family responsibilities, and the impact is, as I said earlier, that the workforce get placed in a position of either meeting their cultural and family obligations that are very real and very, as we would understand, I guess, in terms of immediate family, they exist within that kinship structure, or meeting the obligations of their employer, and where those tensions exist, obviously, it can lead to disengagement or loss of employment or similar considerations, or impact on the family and kinship unit. So I think the sort of tangible concerns that we see is particularly for the health workforce of their work being underpinned by their relationships and their connections and their roles in community, and the tension that places on their obligations to an employer and to a system, and their inability to consistently recognise that both of those aspects add value to someone's role and performance and to the broader society. So I think that the tension is primarily experienced by the individual more than the employer, and as I said, it sort of can impact job satisfaction, retention and engagement quite practically.
Ms. Coker, did you have any questions?
Yes, thank you very much for being with us today. My question was about the, if you can speak further to the types of reasons that Aboriginal and Torres Strait Islanders may require cultural or ceremonial leave.
Yes, certainly. So again, I guess it's a related concept, but there's a number of different reasons that sort of cultural or ceremonial leave or similar terms might sort of apply to Aboriginal and Torres Strait Islander staff. I think firstly, obviously recognising the shared history and the colonial history of the country, that for many there is sort of physical or family dislocation from country and community that people navigate within the modern context of Australia. But certainly for Aboriginal and Torres Strait Islander people within the workforce, the cultural obligations that sit within the context of their identity and their relationships and their role in the nation context of their Indigenous First Nation include sort of roles that might be prescribed from a sort of family or personal context. So people may have particular roles regarding things like law, ceremony, healing, whatever it may be, as well as obviously obligations and participation in the cultural life of the community that may be where they live or may be where they're culturally connected to. And we also see, I guess, a really sort of tangible example of that is the increased, I don't want to say burden, but the increased requirement of the workforce to attend and be involved in business within community, acknowledging that sadly there is a disproportionate loss of Aboriginal and Torres Strait Islander people, and that is again part of people's relationships to community, but also generally speaking the effectiveness in the work that they do, particularly in sort of the healthcare and social assistance context where again those relationships are really foundational to trust, to access and to quality of services and care.
Thank you. I want just a follow-up question there. So what sort of evidentiary, evidence would be, do you think would be appropriate in terms of applying for this leave? Do you think that, bearing in mind the need to avoid culturally unsafe or overly burdensome processes, what would you recommend?
Yeah, so in terms of the evidence that an employer could reasonably ask for from an employee, is that the line of the question?
Sorry, I'm actually having a little bit of a challenge understanding. I don't know if... thank you. We're looking at...
Yeah, it's just about the evidence an employer might accept.
Yes, that's right. That's correct.
Yeah. I think there's obviously some established evidentiary practices around like death and dying in terms of immediate family context that may or may not be appropriate, depending on a person's relationship. I think, again, these are things that could be sort of fleshed out and better understood in collaboration with Aboriginal and Torres Strait Islander organisations around what may be appropriate and culturally safe. I think, again, it probably differs in some degree in context. It's whether someone's living on country or off country in terms of the employer's potential awareness, I guess, of the happenings within a community. But I think, again, if it's properly framed and appropriate guidance is given, there should be a sort of a better promotion of equity versus at the moment more of an ad hoc application of understanding based on employer discretion. So apologies, I can't give a more direct answer, but I think it is something that would have to be sort of worked through in a bit more detail as to what would be a culturally safe practice that could be applied in the context of a national sort of standard.
Thank you for that. And I think just in terms of trying to understand as well the impacts in various parts of the country to, what you've proposed. Obviously, the National Employment Standard is a safety net. It's universal by its nature, but we're aware that there are some people that don't get to equally appreciate some of the protections in there, or there are cohorts that we perhaps need to pay special attention to. So thinking about regional and remote Australians, more broadly, obviously First Nations people right across the country, is there any sort of broader suggestions that you might have about how we could improve that safety net?
I think my experience predominantly is within systems and structures that have quite well-established enterprise bargaining and similar things. So I do acknowledge that I probably know most detail around sort of health and related sectors that are generally sort of good practice, can be good practice. I think there's obviously a really strong educational element around the National Employment Standards, and I think that's an area that accessible information for employees about their rights can be really helpful, and certainly acknowledge that structures like the Coalition of Aboriginal and Torres Strait Islander People organisations may be avenues to support in the development and communication of those sort of resources. I think Again, part of our rationale for proposing that some of these things be included in more of a national context is because it is quite often people in roles and sectors that they may have less power and or are less socially operated, I guess, in their model, are probably the ones that have the least access or the most invariable access to things like cultural leave. So again, I think consideration of what the NES means in those contexts would be helpful, and then if it's an appropriate lever to influence practice on the ground, then the communication aspect, I think, will be an important secondary aspect of that.
For that response, Ms. Coker, did you have any final questions?
No, I'm right, thank you.
Excellent, thank you. We really appreciate your submission and your attendance here today. You will be sent a copy of the transcript to request any required corrections, and enjoy the rest of your afternoon.
Thank you, I appreciate your time.
Thank you very much.
Can't do this on a...
Always good to have people in.
So I now welcome Mr. Charles Power from Holding Redlich to give evidence. For the Hansard record, would you please state your full name and the capacity in which you appear?
My name is Charles McLean Power. I am the Victorian Managing Partner of Holding Redlich, and I speak on behalf of Holding Redlich. Holding Redlich's a law firm.
Thank you very much. Although the committee does not require you to give evidence under oath, I should advise you that these hearings are formal proceedings of the Parliament. Consequently, they warrant the same respect as proceedings of the Parliament itself. Giving false or misleading evidence is a serious matter and may be regarded as contempt of Parliament. I now invite you to make a brief opening statement before we proceed to discussion.
Thank you, Chair. I wanted to share with the committee some areas of the operation of the National Employment Standards that have presented issues for me as an employment lawyer, as well as for the lawyers that I supervise at Holding Redlich. At the outset, the provision in a federal statute of universally applicable set of minimum employment conditions, the breach of which attracts civil remedies for employees, has served Australian workers well. It's ironic that the concept arose in Victoria out of the so-called reforms of the Kennett government in the early 1990s, which underpinned legislative provisions that sought to diminish award regulation. However, today it serves a more positive role, providing a minimum, nearly universal standard to serve as a foundation for more beneficial arrangements through modern awards, enterprise agreements and employment contracts. So I'd like to make some observations on the way that the NES provisions operate. Firstly, Section 62 provides an entitlement for national system employees not to be required to work unreasonable hours in addition to 38 in a week. And the provision sets out some factors that are relevant to considerations of when those additional hours might be unreasonable. And it looks grand on paper, but in my experience over the 30 years of the operation of this provision, I can't think of a case where it's actually run to final hearing. The litigation associated and the decisions associated with that provision are negligible. And that's not, of course, to say that overwork is not a serious issue in Australian workplaces. But it does seem that it's not doing much to achieve its end. And I would suggest that it would be aided if the enforcement of this standard had an arbitral or conciliation and arbitral power in the Fair Work Commission, in the same way that the request for flexible working arrangements has under sections 65B and 65C. So a limited capacity for the Fair Work Commission to resolve disputes about unreasonable working hours, I think, would see that provision achieve its noble ends. In relation to the standard enshrining the rights of a national system employee to request flexible working arrangements, an unresolved issue is the interaction between those arrangements once made and the terms of the employee's contract of employment. For instance, is the arrangement once made a permanent variation to the employment contract? For example, if a full-time employee requests a flexible work arrangement to work less than 38 hours a week, is that locked in to their contract of employment such that they have no right to return to their full-time role? What happens if the employer wants to change the arrangement and it's reasonable to do so? What happens if the employee is terminated or retrenched? What do we calculate their redundancy pay on? Their lesser hours under the arrangement or their contracted hours? And that, for us, that's an issue that's caused us problems when advising employers and employees. In relation to Division 4A, which deals with the rights of national system employees to request casual conversion, the operation of section 66AA(c), subsection 4, paragraph B, allows an employer to refuse an employee's casual conversion request on fair and reasonable operational grounds. Now, this would benefit from greater elaboration than is currently provided under subsection 5. When the new casual conversion pathway commenced operation in August 2024, it replaced provisions that did provide greater guidance as to when it would be reasonable to reject a request. Now it's sort of left very open, and I think it would assist all parties if people understood when a casual conversion request has to be accepted and when it can be properly rejected. In relation to unpaid parental leave standard, the rights of employees who do not have primary responsibility for the care of the child are no longer the subject of provision. And so this is sort of an older concept that you have when you have an employee couple. One has the primary responsibility for the care of the child, and one has rights of concurrent leave. Now, those are no longer in the NES. Yet many organisations still require employees who seek to take the full parental leave entitlement to provide evidence that they are the primary carer of the child. And so there really needs to be sort of some consideration as to whether that concept is gone, or whether it is worthy to retain it. Because at the moment there is a disconnect between the parental leave policies of Australian businesses and organisations and the NES. Subsection 87(3) entitles an award an agreement-free shift worker to a 5th week of annual leave if regularly rostered to work shifts across 7 days a week, 24 hours a day, including on Sundays and public holidays. Now, the meaning of regular has presented some difficulties. There's sort of the Roy Hill rule that it has to be 2/3 of the Sundays and public holidays in a year, but there's also federal court authority suggests that doesn't necessarily apply when you're interpreting the NES. Frankly, the Roy Hill rule is difficult for people, of course, who haven't served a full year and this leave is supposed to accrue progressively. So some consideration of what regular means would benefit all parties, I think. And finally, Division 9 deals with long service leave. It was enacted in 2009 to serve as a holding position pending the harmonisation of national long service leave laws. And of course, this didn't come to pass. And this holding position has provided for less than satisfactory outcomes for certain cohorts of employees that, before the Fair Work Act commenced, had a long. Well, it's complicated, but frankly, it results in a poor deal for casual employees and for employees who end after 7 but not 10 years. And the problem was highlighted in the full federal court decision of Conroy's and Small Goods against Australian Meat Industry Employees Union. And I urge Australian governments, because it's obviously not a federal government issue alone, to revisit the issue of long service leave harmonisation and move to one standard for all Australian workers. And this consistency would be welcomed by employers and employees alike, in my view. So thank you, committee. There's some observations about the NES for your consideration.
Thank you, and that is much appreciated. And I'm sure Ms. Coker has some questions, as I do. And I think a number of observations that you've just made very timely, considering we had a witness who was impacted by the Conroy decision appear earlier today. And the issue of long service leave has come up quite a lot through the course of this inquiry. Different, I think, approaches to how harmonisation or a national scheme would operate, but wondering whether you've got any particular ideas about what would be important components of a system, whether it should be administered by the Commonwealth, whether what role the states and territories may still have in a scheme.
Yes, well, the fact that it's a state and territory matter is peculiar and never been one that I've fully answered. But it's well and truly part of the state jurisdictions, and I imagine there would be a difficult time teasing it off various states. There seem to be, and you would need sort of governments of all persuasion to make it happen. But there just is confusion. Business would welcome it. Because particularly when there is a situation where the extraterritorial application of state long service leave statutes differs between jurisdictions, and that's been again highlighted by some recent judgments, including from the Victorian Court of Appeal in Infosys. So I don't see a way to achieve it other than negotiating the referral of power of that matter or pushing it through the Ministerial Council. As I said, there was that brief moment in 2008 when Labor had all governments, and then the West Australian government fell, and that was the end of it. And so the holding pattern became the status quo for a long time. Yes, it's just going to require the states to move on it.
And something I think we committed to doing a bit of research on as a committee, that I guess stalemate from the period of the Gillard government around the changes that they'd recognised should be made to long service leave that never kind of came to fruition. When we were talking to the ACTU earlier, they weren't quite sure what the obstacle was at the time that meant that we're still here discussing it. Obviously, we've got extensive experience in this area, and you sort of alluded to the fact that there were states and territories who had been of a particular political persuasion at the time who may have been more amenable to working together on change. Was that the obstacle in your view to why we never, as governments, as parliaments, moved on this issue? Or is there something else that happened?
I think industrial relations is something that particular states, New South Wales and Queensland, like to hang on to. The unions like having state jurisdictions. I'm thinking of some of the unions in Queensland and New South Wales. They would be reluctant to see any erosion of the current state footprint. Here in Victoria, there's a bureaucracy that services long service leave prosecutions. It's as it does child labour breaches, and of course it gave up its power in respect of the wage inspectorate. I can imagine that there'd be this sort of reluctance to completely give up, a bureaucracy in this area. It's a bit like when Victoria held out on harmonisation of safety laws. I never really understood why that was, but I remember the Treasurer Palace sitting me down and saying, no, it's going to just cost too much to move to the harmonised system. So there's the case needs to be made for harmonisation. Business needs to get on board, and just explain that it makes no sense to have different long service leave entitlements between different state boundaries.
Thank you. And I think as well something that came out from your observations is the notion that intent and interpretation are sometimes not aligned when it comes to the national employment standards and probably industrial relations more broadly. We have heard from witnesses throughout this process that this has been a real issue, and there are recommendations such as audits of legislation to make sure that things are consistent in definition and or inserting clearer definitions in the legislation in certain places. Just really inviting your reflections on that and how that alignment can be better.
Well, they don't have a blank canvas on this. They've got an abundance of award provisions. So when it comes to regular shift workers, there are award provisions that can be borrowed and appropriated and aligned with the NES. So it's a question of the NES really coming up to the award system on this and not being different on this critical area, I think it's just a question of in certain areas recognising that there is a need for alignment between the NES provisions and the award provisions.
And thank you. And another point that has come out, and again would invite your reflections on, is it's obviously been quite some time since we've had a review of the National Employment Standards, whether there ought to be more regular review processes and what that might look like.
Yes. Well, it certainly should be a living, breathing document, that's for sure. I know that the former president of the Fair Work Commission, Justice Ross, went to some trouble to knock off 4 yearly reviews of modern awards because he just sort of felt like by the time they'd finished it, they had to start again. Obviously, that was a bigger exercise. If you could have a sort of a 3 yearly or 4 yearly review that was sort of limited and truncated, then that certainly would make sense. I mean, there's situations where the government has had to intervene, like things on family domestic violence leave, when there's obvious gaps that need to be plugged. If those kinds of areas or in the safety net are the subject of periodic review, then I would welcome it. Who would conduct it? Perhaps as a specialist panel of the Fair Work Commission. It would be good to have whatever state industrial relations commissions exist have some representation on it, perhaps. Yeah. So some sort of a panel that is auspiced by the industrial tribunals that periodically reviews the NES would certainly make sense. That's for sure.
Thank you very much, Ms. Coker.
Thank you, Mr. Power, for being with us today. My questions just relates to employers' familiarity with the NES and their compliance to it, and how we help them to gain a greater understanding. It's been raised in previous hearings, particularly for businesses, SMEs, small to medium-sized enterprises. And you did actually mention a couple of specific things in your opening statement around the casual conversion. And you mentioned that the need for greater guidelines around how that occurs. And then you also talked about the primary carer, and even though that's not a part of the NES now, that employers still see that as a means of, I suppose, enacting that particular piece of legislation. And I suppose what I'm interested in is, one, do we do better guidelines within the NES? Is there room for further awareness raising amongst businesses? How do we do that? And whose role is it to do that? So that's a lot in one question, but over to you.
Yeah, of course. Of course, there would be certainly a case to be made for more education of employers, especially in the SME sector. I don't think we could lump that on the Fair Work Commission, which is already being inundated and depleted of resources, and a matter of separately of great concern to practitioners. The Fair Work Ombudsman has that role, but there needs to be some sort of incentive for employers to educate themselves. And I often have considered whether or not there's something to be said by giving them an incentive to do so, which is that if they've undertaken a sort of a compliance review process, that's sort of noted when the Fair Work Ombudsman investigates a matter or a complaint involving one of their employees. They get some sort of recognition for the fact that they've thought about what they're legally required to do, and so that when there is an issue, when there is an employee complains, that is sort of recognised, if you like, in a way that gives them some sort of credit, if you like, and.
So do you think that having further guidelines in the actual NES itself would be helpful? I mean,
absolutely. I mean, it's buried in a huge act, and I mean, you have, of course, the Fair Work Information Statement, which employees get, but I wonder how many SME employees have read that.
And you talked about the issue around parental leave and the primary carer, but are there other areas that you think have a level of complexity which are particularly challenging for employers?
Flexible work, requests for flexible working arrangements, the interaction that they have with anti-discrimination laws.
So how do we actually, if this is a particular area of challenge, what do you think we should be recommending to overcome that?
It's hard to codify because it's so discretionary. And I mean, I think it is just something that warrants the subject of a publicity campaign. I mean, in the old days when this was something that usually was done by chambers of commerce in conjunction with unions. There were industry-based campaigns. That's sort of the nature of industrial relations now. Is the Fair Work Ombudsman sort of steps in and commands the field here. Does it have the capacity to do it? No. Look, it really has to be something where there is industry-based campaigns that push out information about what the rights and obligations of the employers and employees are in this area in a way that is most accessible for the industry participants. But again, that costs money. That's the subject of something which presumably would have to be a resource commitment.
But it might be good because a lot of, particularly young people now, are not really aware of their rights either.
Yeah.
So it's probably not just for employers but for workers as well.
Yeah, absolutely.
Am I able to ask one quick final question? So do you think that the principles set out in the NES around flexible work arrangements, which is what I would presume an employer would look at, and it is discretionary to some extent, is there sufficient definition about what flexible work is and the principles around it for an employer to adhere to?
Look, it's not enough, but does it require further definition? Probably not. Ultimately, what you're seeing come through the decisions is a situation where employers can't just say, oh, this role can't be done remotely, just per se, full stop, right? Yeah. And the reality is that is an incorrect assumption on the current state of law, right? So, because it really depends on the person. If the person's an underperformer, maybe. If the person's a long-serving, loyal employee who's always done the right thing by the organisation and the employer, then there's no problem with it. So it's a case-by-case assessment, which really is not going to. Employers wouldn't be assisted by further provisions in the Act. They can only be assisted by understanding that you can't take a one-size-fits-all approach to flexible working arrangement requests. You need to assess it with relevance to the person and
to the needs of your business.
Yeah. This thing that the banks sometimes run, we want a vibe of togetherness in the office, and that's that's just something we value and want. Now, the Commission is just breaking that down and saying, no, that's not sufficient. You need to really look at what this employee does, and accept that it is perfectly able to be done, in the office and at home on a fair basis. So, yeah, it's something which I don't think can be done by legislative provisions. There needs to be guidance. The guidance needs to probably come from the Fair Work Ombudsman, but it needs to be tailored for specific audiences and specific industries. And of course, it requires resources which just aren't there at the moment.
Maybe the resources are important if we want to keep people compliant and understanding of what the NES expects.
Absolutely. And the NES is something that we should be proud of as Australians. It's a universal standard, and it truly is not negotiable, as countless court and tribunals' decisions have shown. And we should value it and we should support it.
Thank you.
And going to the Fair Work Information Statement again, and I guess the resources that are required to make sure everyone understands their both entitlements and obligations. We've heard from a number of witnesses and in written submissions around improvements that could be made to the Fair Work Information Statement so people more clearly understand the nature of their employment. We've heard recommendations around contracts of employment being more clearly offered to all employees. Just inviting your reflections there too in relation to any improvements that could be made.
I did see in one of the submissions, I think from an academic, Hilary Charlesworth maybe?
Sarah Charlesworth.
Yeah, Sarah Charlesworth, about adopting the New Zealand model of a, you know, because of course it's not a legal requirement to have a written employment contract in Australia.
Yeah.
And that does have a lot of appeal for me. I mean, the Chambers of Commerce will hate it, but ultimately it provides an excellent opportunity to have things set down in writing as a requirement. And a written employment contract will advance the protections for an employee obviously to a far greater extent than some unwritten deal. So I think there is a lot of merit in that, and that would be an opportunity to spell out clearly for the employee what their rights are. And it doesn't seem to have cruelled productivity in New Zealand, but of course I say that just without any empirical basis. But I support that sort of direction.
Thank you very much. Just thank you for your attendance here today and for your observations and comments. You will be sent a copy of the transcript to request any required corrections, and I hope you enjoy the rest of your afternoon.
Yeah, thanks again.
Thank you. Thanks very much.
Thank you.
And now welcome Mr. Jonathan Wolfrey from the Australian HR Institute to give evidence. For the Hansard record, would you please state your full name and the capacity in which you appear?
Thank you, Chair. I'm Jonathan Wolfrey. I'm here on behalf of the Australian Human Resource Institute, primarily as its chair of our National ER and IR Advisory Panel.
Excellent, thank you. Although the committee does not require you to give evidence under oath, I should advise you that these hearings are formal proceedings of the Parliament. Consequently, they warrant the same respect as proceedings of the Parliament itself. Giving false or misleading evidence is a serious matter and may be regarded as contempt of Parliament. I now invite you to make a brief opening statement before we proceed to discussion.
Thank you, Chair. And it's my pleasure to be here today and to support the committee in its important work. For context, the Australian HR Institute, or RES I will refer to us as, is the professional body for the human resource profession in Australia, with approximately 18,000 members across the country. I chair RE's Industrial and Employee Relations Advisory Panel, and I'm an outgoing state president and board director as well. And in my ordinary life, I'm a practitioner in the human resources space. RE's members reflect the full breadth of the profession. That's from independent consultants to small, medium businesses, solo operators in small to medium organisations, or members of big specialised teams in big organisations as well. They work alongside managers, business owners, and people that carry employment obligations across the spectrum. The profession itself has matured quite significantly over a number of years, and a lot of that's by demand to do with employers requiring that specialist expertise. We have professional standards and certification for our members and for HR practitioners across Australia, and these set the standards for how they operate. As you likely know, AREA is not an industrial party, and we don't come to this inquiry from any particular perspective, not from an employer perspective, not from an employee perspective, but as people and members that work in organisations that experience the impact of employment regulation, legislation and that change. So we believe that we have a unique insight into how legislation lands in organisations and what some of the benefits and challenges are. We start from a simple premise, which is work inside organisations is something that people do together, and good work serves both employer and employee and those involved in the employment relationship. We say that a well-designed work in a well-run organisation benefits the employee doing the work and the employer providing it. And bringing these two interests together is the substance of HR practice. From that premise, we support the principle of the National Employment Standards, that is a universal floor of fundamental rights that applies to every employee. Our members affirmed that principle when we surveyed them, and nothing in our evidence argues against that. Where we do have some views and our submission focuses is where it's become harder to give effect to that principle. As you're probably aware, the standards themselves, designed to be that more simplistic floor that all those involved in work could understand, runs from section 59 to 131 in the Fair Work Act, operate alongside modern awards, enterprise agreements, individual contracts and a range of other instruments that govern the workplace. We know that in the last 3 years alone there's been a significant amount of legislation and legislative reform that have added further obligations into that framework. Our research in 2025 found that many of those reforms did contribute positively to organisations, including on concepts such as job security and wellbeing. The same research that we undertook found that organisations are experiencing significantly increased workload in regards to implementing these and making sense of them and trying to apply them as intended. This is not just with HR practitioners, but in all those involved in the workplace, whether that be managers or employees that are trying to understand what they're obligated to do and what they're entitled to as part of that. And there has been some challenge in that particular area. Our survey on the standards, which we have cited, called for priorities in regards to clearer interaction between the NES and awards and agreements. What our members describe is not a problem with the level of entitlements, but it's a more accumulative complexity and in some cases a certain level of detail that the system provides in those entitlements. And I would add one observation from practice, and this is probably a bit at the heart of how HR operates within an organisation. The overwhelming majority of workplaces, whether they be employees or employers alike, want to do the right thing by each other, and in the majority of cases they do. Regulation is sometimes framed about fixing challenges, closing loopholes or addressing bad actors in the employment relationship as well. And there's obviously a role for that. Sometimes trying to address those bad actors in the employment relationship, and they may be minor, sometimes creates a compliance obligation on the compliant majority as well, and that needs to be considered. Regulation, and we would say that a well-trained certified HR practitioner plays an important role in making sure employer and employee interests find that balance so the organisation or the business can perform at its best. Our submission makes 3 primary recommendations, and I'll just paraphrase those in terms that the committee might consider. The first is in regards to the interaction between the NES and modern awards and enterprise agreements. Improving the clarity of that interaction, and in some cases simplifying or even harmonising the instruments themselves, would do more for everyday compliance than perhaps any single change to standards or introduction of new standards. And we would encourage the committee to turn its mind to what this might happen and in any kind of actions, recommendations or reports that do follow. The second is simplification and consolidation of the standards so that NES remains connected to its primary purpose. That's a clean and usable floor of fundamental entitlements. And third is in regards to sequencing, so addressing that coherence and that overlap that does exist between certain things as a primary purpose before or perhaps in conjunction with considering the expansion where evidence may support expanding entitlements as well. So overall, I'm grateful for the opportunity, and I know AREA is grateful to be invited here today and happy to take any questions you may have.
Well, thank you very much for being here today. Thank you for your submission and for your comments as well, May, just then. I think you may have heard this question be asked of our previous witness, but I'll ask you as well now, which is around what a regular review mechanism might look like for the NES. And the reason I ask is it's come up a little bit so far in this inquiry, and I think through the course of this inquiry, it's become clear that along the journey from the inception of the NES and now there have been a few bumps or perceived bumps, and obviously not having these kinds of things linger for too long is always ideal. If there are problems, you know, we can get together and try and review things. So just, yeah, inviting your reflections on what that might look like.
Yes, thank you, Chair, for that. Probably just to provide context as well, I think the majority of things that we at ARI have provided as well is more the implementation challenges and what we're experiencing there. We don't have, as you would see from our recommendations at this particular point, strong recommendations for what should happen as well. But I could probably speak to that, but I'm more than happy to speak to it. So just caveat, this may not be official positions from ARI, and I don't speak outside of that, but just a bit of a narrative about that. So looking at that, obviously reviewing legislation and changing it is a very cumbersome and an intense kind of process as well. So legislation, and I'm not telling you anything that you probably don't know better than me, it should be there, and it should be seen as being something that's relatively staid and stable, and changing legislation rightly has a significant amount of rigour attached to it and requires the processes that it does. So I think in regards to the review mechanisms for NES, it's about looking at what the right balance of detail is in the legislation in and of itself, and then understanding, you know, different different legal instruments that sit under that framework, such as awards, agreements, and even case law that supports that. And executive government, of course, looking at what best sits in that, because that's clearly more flexible in regards to adapting and responding to, you know, the ever-changing nature of workplaces, and things that they're rapidly dealing with every 2-3 years. I won't go into the common challenges at this point the workplaces are facing as well. And I think this is consistent with our submission there. I think, you know, in our first recommendation in there is about looking at things, looking at the interrelationship between NES and things more broadly. It's about simplifying the section in the award that relates to the NES and making sure that that is the absolute fundamental and clear and the non-negotiable kind of purposes there. And then providing further guidance or instruction through other instruments that do exist, such as award agreements, executive government policy, and different things like that as well. And I think that would mean that, you know, the periphery challenges that the NES attempts to deal with can be dealt with and can be more flexible and reviewed as part of that structure outside of legislation, where the legislation in and of itself provides that real clear and direct articulation of what the NES and what the people of Australia through their government expect to be in there. Does that make sense?
It does, and it leads me to another question around a theme that has emerged through the course of this inquiry, which is the intent and interpretation of the NES are not always aligned, and just again inviting your reflections on, particularly in respect to the items in your submission around the interaction between the NES and the modern award system.
Yes, for sure. And look, I think as legislation gets amended and the political party of the day makes their legitimate decisions about how this should go, different things are inserted into that legislation, and then the interactions then create some kind of friction in there as well. Just one brief example might be the NES clearly cover maximum working hours and provide information on provide a statement in regards to reasonable additional hours. And we've recently had the right to disconnect, which has been introduced into the Fair Work Act, but in a different section. But they do interrelate and they do overlap and different things like that as well. So there are certain things where, just by the nature of legislation, as I'm sure you're aware, that introducing different things sometimes has interacts with those other kind of elements as well. May I ask you to repeat the question as well?
Yeah, no worries. It's really just around the intent of the NES and some of the provisions in there, and then some of the interpretations. And I guess this perhaps goes to the way the modern awards exist, where there might be, as we heard from previous witnesses, definitions for what regular might mean in one context that's not necessarily applied in another.
Yeah, I would simply probably support the fact that the NES as well, and we know the standing that they have in the hierarchy of legislation and things like that. We feel it's very important that the consistency of terms and language in the legislation, the NES and awards should be consistent as well. So there are a couple of examples, and we have put those in the submission, where there's certain awards, and rightly so for their industry or occupation, have introduced different or enhanced provisions as well. But sometimes, unintentionally perhaps, they've introduced different or more narrow definitions of certain terms that the NES deal with, and that creates an interpretation difference. Probably to note, there's clearly protections in the legislation to make sure workers are better off overall and the like, so awards do follow that particular pathway, but that's harder to assess a lot of times when it's a difference in interpretation and language as well. So there are a few, and we have put in a few of those examples that our members are feeding back to us, where definitions of different things such as shift work, redundancy, and different things that a small number of awards have taken and reinterpreted now in their context. So completely appropriate, but I think the byproduct of that is, lawyers can figure that out, case law can support that, but those trying to operate within that framework are like, okay, I'm looking at the award, I know how the NES relate to that as well, but which one am I listening to and what does that mean and what does that think? So the practicality of it being useful is sometimes impeded by that inconsistency of language that has emerged through, industry-specific negotiation. That does make sense, but it's created perhaps that challenge.
Yeah, no, thank you very much for that. Ms. Coker?
Yeah, thank you. And look, I'm just actually following on from what you've just discussed there. So you state that the NES guidelines regarding maximum weekly hours are relating to the 38-hour week and plus reasonable additional hours, that it can be confusing. And you've raised a couple of other examples as well around annual leave and notice periods. So basically, I think what you seem to be saying is that the guidelines within NES do not always align with awards and enterprise agreements, and so there's confusion for employers. So how do we more successfully align these two things? I know that in a sense the NES underpins awards and enterprise agreements, but I can understand the challenge for employers when they've, on the one hand, they've got an award, they've got an enterprise agreement that they're negotiating, and then you've got your the NES. How do we better align them so that employers have more clarity?
Yeah, it's a very good question, and no doubt an intractable challenge to work through this, but there's plenty of wise people either making submissions or making decisions in this area. But it's a good question. What I would say in regards to that is about look, going back to the premise of what the NES is there for, and hopefully my understanding of it anyway is that it's there to provide a simple, clear, as simple as possible, simple, clear understanding for those that use it. Often that's workers, managers, employees, everything like, not just lawyers and specialists, provide that kind of simple language. So the NSM themselves, the simpler they are and the more clear they are, the better they can be used. And then, as I've talked about, is the interrelationship between the language. So to your point about maximum weekly hours, so in practical sense, a manager hoping to do the right thing will go to that, and it will say in there, plus reasonable additional hours, and words to those effects. So they're interpreting that in their own particular way. But we know, particularly if we practice in this area, but that doesn't absolve you from responsibility to paying what's owed for work delivered, and things like that as well. So there may be some opportunities. So maximum weekly hours is a good one. We can't spell out there every single eventuality for every single context, but just a rewording of that language so it's clear, maximum reasonable hours, and then words in there to the effect that as long as they comply with what you are required to pay that individual and things like that. So I think on one hand, it's making it very clear and putting the mind of the reader into that, which the NES is generally people diving into legislation, which may be rare, but the manager making that decision. So that, and then making sure that there's not inconsistency to how that practice is in there. We probably don't want a manager or an employee looking at the NES and then we don't want to teach them that then you have to go to the award and agreement and things like that. So we want them to look at that and with reasonable confidence go away and have the basis for making a decision from there, and only in unique and complex cases then have to delve into more complex things. So probably just to summarise, clarifying and through the use of, and we're more than happy to provide on an ongoing basis, what the practical experience of misinterpretation of different parts of the NES. That was one example.
Do you, sorry to interrupt, so do you with your membership, do you provide them with that sort of information and support so that there is clarity?
Yes, we do. So our institute provides it in a number of ways, resources, helplines, different things like that, so that HR professionals...
So you've got written content, nearly like fact sheets of this is how you respond.
Yes.
It'd be interesting to see some of those, actually. I don't know if we have them, but just to get an idea of what's happening out there and how that could be, more broadly distributed.
Yes, for sure. I can say that we would be happy to provide you some examples or samples of that to show how we do. And just to probably note, if I may, that recognise the work of the Fair Work Ombudsman and a lot of guidance that they have as well. We're aware and we're not competing in a way of that, but ours is obviously more specialised and customised to HR practitioners that are living and experiencing these. But these are challenges that, a single operator may have in a single organisation, and our institute provides that support and guidance.
Well, good on you, because often awareness seems to be a real issue. And you've got 18,000 members, so if we can actually help them to do their job better, that's a great thing.
Yes.
Thank you.
Thank you. I understood we might have Ms Fernando, another committee member, joining us on the line. I know, looking at the disembodied speaker there. So she may jump in with a question too, but to kind of get to some of the specific and technical elements, I guess, where people have described as in need of reform. The two that kind of pop out through this inquiry have been long service leave and paid parental leave. Given the kind of work that the Institute does with all of your members, I just would really love to hear your thoughts in relation to how it's working and where improvements could be made.
Yes, for sure. So that was long service leave. Would you like me to start there?
Yes, please.
Thank you, Chair. So we don't have an official position on whether or not long service leave legislation across the country should be harmonised or otherwise. I know some submission has spoken to that. But again, more broadly, I think the complexity that multiple pieces of statute add to employment relationships, and we know that many employers operate nationally, so have to transverse a lot of those pieces of legislation. It generally makes sense by extension that the less legislation, complexity and inconsistency would lead to, the harmonising of long service leave and looking at how we can make that more simple for employers, because yes, long service leaves acts in jurisdiction of states clearly are an additional consideration, like whilst referred to in the National Employment Standards, of course, and an additional complexity that people need to navigate in the workplace. So recognise that there is an incredible amount of inconsistency people are having to deal with and struggle with trying to interpret and apply that. And by extension, I think simplification in that particular area would be welcome and beneficial to being able to do the job in organisations.
Thank you. And the other area was paid parental leave. Particularly, we hear around the requirements before you can access unpaid leave and what that might mean for return to work, for instance.
Yes, for sure. I think, again, no explicit position in regards to paid parental leave and entitlements and where they should go, but to acknowledge that the standards in workplaces do continue to evolve and emerge, and our society expects more from employers across that journey. So recognition that that's a legitimate decision that our government can make, of course. Of the National Employment Standards, and particularly as it relates to parental leave, is the most voluminous component of the National Employment Standards in and of itself. Now, I've spoken in there earlier, I'm not from a design perspective, it could be the legislation in itself, and whether that level of detail needs to be specifically in the NES or otherwise could be reconsidered. Does it fit? Not to take away from any of the entitlements that already exist, but just to make it easier to understand what is the entitlement and what is the process for which people need to work through to access it. What are the circumstances that support that? So there is definitely room, I believe, in parental leave more broadly, and then obviously by extension paid parental leave, to look at what that entitlement is, but then to look at the detail and the process and procedure, including some of the definitions for doing that. Generally, again, whilst we don't have a specific position, for the most part, where it is easier if there are not different groups of employees in organisations that have different terms and conditions, unless there's specific reason for that. Acknowledging, as a side note, small businesses and what's provided for in different pieces of legislation makes absolute complete sense in the vast majority of those circumstances. But for the most part, where possible and where it's able to be sustained, then the processes for doing things should be as consistent as we could possibly make them. Probably just to note on top of that as well, paid parental leave is a really important area, and a really important area for our community more broadly to consider how we support that in workplaces as well, and how our community more broadly supports that, and how our government support that as well. We need to be mindful, like obviously, as you would know, many employers have decided to go over and above what the minimum requirements are there and choose to do so, and that's really important for their workers to do that, and they've met that need as well. So it's a balance of organisations that do see the need, and many good employers have made that decision to move forward. Just to consider, and we don't have that position, is that an obligation that our society now thinks that should be the minimum standard in all organisations? We don't have a position there, but we acknowledge the questions and the submissions that have the right to ask that question. But we would probably, just to summarise that, focus on where, if this is being considered, that we make sure that the procedure, the implementation of that is clear, specific, simplified, and maybe gives rise to looking at what sits in NES, what sits in the Fair Work Act more broadly, and then what sits in other kind of instruments that can respond to different needs from different employers and sectors, as well as community expectations.
Thank you very much for that. And I'll just check, Ms. Fernando, are you on the line, and did you have any questions?
No, Chair, I have no questions. Thank you.
She's on the line. Excellent. Well, with that, unless there are any final questions? No, thank you. Thank you very much for your attendance today and for your submission. Really appreciate it. You will be sent a copy of the transcript to request any required corrections. Enjoy the rest of your afternoon, and I declare this public hearing closed. Thank you.
Thank you, Chair.